Good morning, ladies and gentlemen. Welcome at our conference on specialized courts in the capital market and corporate law. We are very happy to welcome our speakers and the audience. When we first planned this conference, we very much hoped finally we will be able to do it on site, but due to the situation currently in Austria, we are still in the lockdown. We need to move to this online platform, but we also decided to split this conference into two blocks, with the second block following exactly in a week from now, next Friday, and we hope the other block will be held on site. So this hybrid format will be today only online, and on the 17th of December, hopefully on site here in Vienna at the premises of Polish Academy of Sciences. And on behalf of the Polish Academy of Sciences Scientific Center in Vienna, as well as our partners, Vienna University of Economics and Business and Center for European Company Law, under the aegis of which this conference is organized as a 9th event in the series, in a tradition that goes back all the way to 2005. I'm very happy to welcome everyone. And I will just say a few words, introductory words, and then I will hand over to our key guest, who will also welcome you on behalf of our partner organizations, and then we will move on to the sessions and to the keynote. And to start with, as I mentioned, we are in Vienna, and I speak on behalf of the Polish Academy of Sciences Scientific Center in Vienna, and actually, this is a paradox. We have a very limited credibility when it comes to specialization, because our center is quite general. We are supposed to support Polish-Austrian academic exchange in all fields, so there is very little specialization, so to speak, in our center. So this credibility to address the issue of specialization might be limited, but due to our very reputable Polish, Austrian, and international partners, I hope we can signal some credibility to the topic. The partners, I will skip mentioning them all. You see them clearly on the slide. This topic we have been working on for quite some time. It all goes back to the year 2017, when I was first asked to draw up a draft legislative guidelines for the establishment of a specialized capital market court in Poland. It was an assignment from the Warsaw Stock Exchange. I worked on this with my colleagues, Michał Bobrzyński, Kamil Nowak, and Krzysztof Grabowski, who will also speak later. Why is it so important? We see the world around us, the world of labor, is characterized by a progressing specialization, and this is obviously true for legal services as well, specifically for the development of law firms. And since various branches of law are becoming increasingly complex, the market correspondingly creates demand for expert knowledge for specialized attorneys. And we see this around the big law firms. They have now dozens of departments sometimes, IP, IT, energy, competition, M&A, corporate, capital market, litigation, construction, labor, white-collar crime, and many others. On the other side, we see a rise of boutique law firms who seek their competitive edge in sometimes very narrow specialization, with a portfolio of very specific cases handled and advisory in this very specific fields. Judiciary also embarks on this specialization trend, although, as we also see, judiciary remains behind the developments on the private market in the law firm sector. Now, whenever we think of judiciary, we usually, and this is this traditional way of thinking, we see judiciary as one of the three branches of the government, of authority, of public authority, of power, along with the legislative power and along with the executive branch. And this obviously is correct and true. But what we probably don't get to realize frequently enough is that judiciary, more than legislative power and more than the executive branch, is closer to citizens, is closer to businesses. And we should also look at judiciary to see its dual nature. It is not just one of the branches of the government. It is not just one of the branches of public authority. It is also a provider of public service. And if we emphasize this latter dimension, that is, along with the former one, we should see also judiciary along with other providers of public services, schools, universities, healthcare. And this is so often overlooked. And whenever we realize this dimension, other keywords should come up to our mind. And those are organizational culture and customer friendliness, how efficiently and how, so to speak, customer-oriented judiciary is. What is the culture? And does this culture come any close to what we see on the private market? We are focusing on corporate litigation, and we are also focusing on settling investor claims on the capital market, on the financial market. And we see corporations have very sophisticated efficiency-oriented culture. How far can we say the same about judiciary? So this will be one of the aspects how we will look at the courts as we discuss this today and next Friday. We will talk about the pros and cons of judicial specialization in general, with a particular focus, as I mentioned, on corporate disputes and on capital market. As we know, when we look at substantive law, we see progressive Europeanization. We see progressive harmonization and oftentimes even unification of substantive law. We see a lot of this in corporate law, but even more so in capital market law and in financial regulations, where European law actually prevails, and the substantive law is today more European than just national. But the law that we have on books is one thing, but how this law is interpreted and then eventually applied is left up to public authorities, and among those to the courts, which are organized by the countries. There is no or very little power on the side of European Union to decide on the structure. On the structure, there is actually no side. There's only discussion about certain criteria. And there are some aspects, and those would be my final words, that I would like to draw our attention to. I already mentioned the organizational culture. This orientation towards settling claims effectively. We see on the capital market and in corporate law, those fields have become very, very complex, multi-layer nature of the sources of law. And also the time is the key aspect, specifically when it comes to deciding on corporate affairs. When we have a dispute concerning appointment of the directors or general meetings, time is of essence, and we want to have not just final judgments rendered quickly and efficiently, but also there is a need for injunctions to be rendered very quickly. The question is this need is addressed in a proper manner. A second aspect is a certain paradigm shift. We are meeting now online, and our speakers come from different countries, and the distance is not a problem today. The judiciary often is still organized based on this traditional paradigm of geographic proximity, so that the justice should be brought close to citizens. And of course, it is understandable when it comes to family disputes, maybe also labor law, maybe criminal law. The court should be located physically close to citizens. But when it comes to business, distance is not of significance today. What matters today is is competence, is specialization. And if the court is in one city or another city, it does not really play a big role. And I think pandemic helped us understand this even better. And the fourth point, because I finish, is a very important one. And this one is judicial independence. And we are witnessing a discussion also in Europe, in Poland, other countries about judicial independence. And there are some aspects that I think deserve also a closer attention. And they are often overlooked in the discussion on judicial independence. Because what does it mean to apply the law? What is the dividing line between the law, and as we know, the judges are supposed to know the law, cura novit jura, right? Curia novit jura. This is the principle that is widespread in Europe. But when it comes to very complex questions of financial instruments and other very sophisticated fields of law, and when we have a generalist judge confronted with those, we see often expert witness to be invited, and the dividing line between what is law and what is specific knowledge gets blurred and blurred. And as we see from the practice, very often expert witnesses decide actually on the case, and the court just follows what the expert witness delivered. At the same time, we have no any guarantees in place to guarantee independence of expert witnesses. So it is quite important question when it comes to judicial independence. And the more specialization we have, the narrower the narrower scope for expert witnesses, and the better guarantees for judicial independence. But on the other side, if we have case law concentrated in just one court in the country, on the other side, it would be way easier for a lobbyist to try to exercise influence in this one very particular point, rather than throughout the country where we have many courts to decide on litigation. So therefore, there are some chances and risks when it comes to judicial independence that are connected or related to the specialization in judiciary. And having said this, I would like to give opportunity to our special guest today, and I would like to hand over to Professor Martin Wiener, who will speak on behalf of Vienna University of Economics and Business. Martin, please.
Thank you very much, Arek. I would like to warmly welcome you here in Vienna, unfortunately only virtually, on behalf of VU Vienna, of the Vienna University of Economics and Business. And I would like to thank Professor Radwan and congratulate him for the excellent program he has prepared for us for the next 2 days, which I really am looking forward, because this is a very important issue, and the difference between generalized judicial expertise and specialized knowledge is, of course, an issue in any legal system and for any legal system. And any legal system will continually have to strive to find the right balance between these two factors. And Professor Radwan has mentioned a number of factors: specialization, knowledge. He has mentioned regulatory capture at the end, independence of expert, independence of other influential players. And I'm certain that we will have an opportunity to touch on all of these and many more issues in this today and next Friday. So this is an excellent program with extremely interesting presentations and issues, and I'm certain it will be hugely enriching for me personally and all of us who have the opportunity to be together here for 2 days of interesting conference. So I will very brief and stop here, just in order not to hold you up too much from the really interesting things. Thanks, Arek, for the organization. And well, I'm really looking forward to what we're going to hear today and next Friday. Thanks a lot.
Thank you very much, Martin. Just to remind everyone, Professor Wiener will have his presentation next Friday, to which I am very much looking forward, and I also invite every one of you. 2 days in this exceptional situation means not just today and tomorrow, it means today and next Friday. Now I would like to invite Pavlos Masouros, who is has many roles, but he will speak on behalf of Center for European Company Law, which is also our key partner, which is also umbrella organization for many institutions. And this very conference is under the aegis of CECL. Pavlos, please, floor is yours.
Thank you, Arek. It is a pleasure to virtually be in your company today. And on behalf of CECL, I can say that we are excited to partner up with the Polish Academy of Sciences, the Vienna chapter, in relation to the conference that is going to be held today and next week. At the Center for European Company Law, we've always been very interested in business and corporate litigation. Our latest conference a few years ago in Rome dealt with alternative dispute resolution mechanisms in corporate law. And we're very happy that this conference is going to deal with litigation with specialized courts and litigation therein in relation to corporate law. As is the case, arbitration is always very interesting for corporate practitioners, but we all know that there are issues with the recognition and enforcement of the rulings of the arbitral awards. So it has always been very intriguing for anyone who is practicing corporate litigation that at some point in most jurisdictions, a specialized corporate court would emerge that would not have the issues that the arbitral venues do. So we're excited that we're going to be learning a lot in relation to developments in a number of jurisdictions as far as specialized corporate courts are concerned. And again, Arek, thank you very much for being our host today and next week. And thank you once again for being so accommodative of CECL and its endeavors. So I'm looking forward to some very interesting presentations today and next week.
Thank you very much, Pavlos, for your kind words. And now we have our final speaker in this welcoming session. Surprisingly so, because Mariusz Hałady, whom I would like to welcome now, who is the General Counsel to the Republic of Poland, was supposed to welcome all of us next Friday, but since this is not certain yet, maybe it next week, but so therefore we decided to kindly invite you to join our opening session now. And the added value of this conference is international dimension, but it is also to bring different aspects. We have judges, we have attorneys, we have academics, and we also have someone who has hands-on experience with litigation representing state treasury, which I think adds value. Mariusz, I would like now to hand over to you. Floor is yours.
Thank you, Arek. Good morning, ladies and gentlemen. I would like to start by saying thank you to all the organizers of this conference. I'm grateful in particular to Professor Arkadiusz Radwan and the employees of the Scientific Center of the Polish Academy of Sciences in Vienna for addressing such an important topic like specialized courts from the business perspective. Nowadays, we observe a trend to specialize highly in a selected field of law. This is what boutique law firms do, providing tailored services to a narrow group of clients. This is also visible in corporate law firms or even government-related legal offices. What comes as no surprise is the emergence of highly specialized regulators overseeing specific market segments or even ombudsman offices taking care of narrow groups of clients or consumers. Somehow we can even say, in contrast to this trend, we observe the continuance of a generalist approach to a law among professional judges, who still, in most jurisdictions, deal with a vast and diversified array of disputes. This type of approach, along with the insufficient expertise, may lead to certain issues like difficulty in applying the provisions of law properly or understanding complex factual background of certain cases. Disputes related to capital and financial market transactions could be a very good example of such cases. As Richard Posner himself once observed, a judge confronted with such problems sometimes reacts not by trying to properly understand a case at hand, but by relying on legal technicalities, and he or she does not get engaged in the substance of a dispute. Such situation is an contradiction not only with expectation of parties seeking the protection of their rights, but also with the very nature of the right to court. One of the natural and inevitable responses to rising demand for a specialization in the judicial profession is the growth of alternative dispute resolution area. Proponents of arbitration often point out that it enables parties to appoint arbitrators best qualified to solve a given dispute both in factual and legal dimension. The same can be said of the parties free to choose a mediator or conciliator. The advantages of IDRs are undeniable. In fact, the office, in the office I have the honor to be the head of, the General Council of the Republic of Poland, a few years ago established itself a court of arbitration and is actively promoting mediation with the participation of state-owned companies. Nevertheless, IDRs cannot be regarded as a universal cure to all problems of the judiciary. IDRs have their limitations, especially in the areas regulated by the public law, where the outcome of a dispute is relevant not only to parties, but also to the society as a whole. The recent case law of the European Court of Justice, initiated by landmark ruling the Acmea case, can serve as an excellent example in this regard. This leads us directly to the topic of our conference, closing the justice gap in investor protection. I'm honored and delighted to be invited to this honorable circle of distinguished experts who will address the topic of specialized courts from the perspective of capital markets disputes. It seems that in many regards establishing such courts may become an answer to the growing need to provide professional and efficient judicial protection to investors involved in capital-related disputes. There is a hope, not unfounded, that such solution would inspire trust in the justice system, contribute to boosting investment and lower investment-related risk, because higher trust in the legal system is always beneficial to the economy. We believe that specialized courts represented by dedicated specialist judges would help to keep consistency of judgments. More predictable case law and more efficient procedure can encourage parties to settle their disputes, and of course will also help to reduce the caseload in the long run. On the other hand, maybe risk connected with the lack of judicial specialization should not be overestimated. In certain categories of courts, including the highest ones, it's difficult or even impossible to attain the high level of specialization, yet judgments of these courts are often widely respected. Excessive specialization of the judiciary can result in the fragmentation and lack of coherence of the legal system. With this in mind, it's always necessary to carefully consider where and to what extent specialization is needed. That's why the subject of judges specialization and specialized courts is a fascinating one in terms of the potential and consequences it brings, as well as limitation it may require. I'm convinced that the present conference will bring us closer to proper understanding of this matter and will help to formulate certain postulates, or will even lay some groundwork for the future legislative works. Once again, I would like to cordially welcome all the honorable speakers and guests and wish you an interesting and effective discussion. Thank you very much.
Thank you so much, Mariusz. We have our welcoming round completed now, which allows me to invite our keynote speaker and move to the next item on our agenda. And the keynote address will be delivered by Jacek Jastrzębski, who is a professor at the University of Warsaw, and since I think 3 years now, the chairman of the KNF, which is the Polish Financial Market Supervision, with a former experience in the banking sector as in-house attorney, and with international experience as well. Jacek holds LLM from Berkeley, and he will share with us his views on the ideas and prospects of judicial specialization, specifically when it comes to the discussion on establishing a specialized capital market court in Poland. I don't see Jacek with us, but I guess Ernest is coordinating everything.
I'm here.
You are already here. So Jacek, having said this, I'm very, very glad to see you. And well, please, the floor is yours.
Thank you very much, Adek, for this kind introduction. Ladies and gentlemen, I'm pleased to meet you online today. I hope, and there are still some chances that we'll have the opportunity to meet in person in a week from now, but let's see. Let's keep our fingers crossed. I'm very grateful to Adek for having us as a partner of this scientific event, along with the other reputable institutions whose logos or names you can see at the bottom of the slide. And what I would like to do in my keynote speech is to flag some, first of all, to provide you with some general remarks or comments on how we see the trend of specialization and what we believe to be the main advantages of this trend. And then I would like to dig into more detail on the proposal that was submitted some time ago by the Arahant Institute, a proposal for a capital markets court that could be established in the Polish legal system, because we, as the Polish Financial Supervision Authority, of course, we are also a key stakeholder of this undertaking, and I would like to share with you some comments that you have from our point of view as the Financial Supervision Authority. So to start, of course, it's needless to say among the participants of this conference, but just as a starting point, of course, I have to point to the growing complexity of capital markets legislation and regulations, which currently are a multi-level set of regulation issued both at the European level and at national levels. The capital markets regulation or legislation consists of various pieces of legislation, starting with very general ones at the level of directives or even at the European treaty level, and then going down and down to pretty technical regulations or technical guidance, which are issued, for example, by the European Securities and Market Authority, but also by regulators at the national level, including the Polish Financial Supervision Authority. We have also our piece in this regulatory and legislative work, issuing soft law regulations that are addressed to our supervised entities. And the complexity of legislation and the complexity and ever-growing amount of legislation in the field of capital markets has become even to be pointed as one of the risk factors, or one of the risks that are potentially relevant for the capital markets and its participants, because the time and the skill and the resources it takes to stay up to date with this set of regulation is becoming more and more considerable, and also there is some cost attached to it and some risk attached to it. So that of course speaks. And one thing that of course also is worth mentioning is also the decisions of the Court of Justice of the European Union, which in its jurisprudence often touches upon notions or topics or concepts that are very fundamental for the operation of the financial system. Now we have seen the activity of the court in connection with consumer cases. That this was particularly relevant for the Polish banking market, but it may also become a relevant topic for the capital market, because the consumer protection is at the heart of the European regulations. And what we see also from the financial supervision perspective is that the activity of the European Court of the Court of Justice of the European Union is becoming a more and more relevant part of the picture of the regulatory landscape, so to say. That of course provides us with arguments speaking clearly in favor of specialization, because it is becoming more and more difficult to stay up to date, to follow all the regulations, to be at the heart of the regulation. So that clearly speaks in favor of giving the right to adjudicate in disputes related to the operation of capital markets to individuals who can devote all their time and all their professional efforts to this area of law, which may not be the case in court of general competence or in general court. So this is clearly an advantage of the specialization. Jacek, in his opening remarks, mentioned some trends that additionally support these observations. So the trend that has become like a hype of the recent months is the trend related to digitalization of many operations. What we see in the business, but also in the public administration, is digitalization of almost all processes, front-end processes, sales processes, but also back office processes related to claims handling, also to the operation of the judiciary. And this is also a factor that very much supports the idea of the specialization in the judiciary. This is related to the fact, which Jacek also mentioned before, that what we've seen so far is that in the organization of the judiciary system, the territorial availability seems to have played a significant role. But with the widespread use of ICT technologies, of remote access, of remote procedure, this allows for a gradual departure from the traditional paradigm of the territorial availability towards a new paradigm of, let's say, digital availability, which makes it far easier to centralize some functions and also to specialize them, because centralization and specialization probably goes hand in hand in this case. And I would also like to refer to some of the arguments that have been raised in the document prepared by the Allerhand Institute some years ago, the document called the Assumption for the Court of the Capital Markets. And the arguments that have been raised in this report and that we share, and that are also kind of like substantiated by our supervisory experience, are the following. So first of all, this is efficiency, and efficiency comes also from the fact that the judges that are specialized or that will be specialized, they can immediately identify the key issues in the dispute. So they focus their attention on what is the heart of the dispute, and they don't have to spend too much time or too much effort on identifying what is the real source of the dispute between the parties, which of course allows them to streamline the procedure in a significant way. This is also related to the second advantage, which means that they can significantly limit the amounts of evidence that will be taken in connection with the proceeding, because the evidence will be by definition limited, or should be by definition limited, to this evidence which is relevant for the resolution of the dispute at hand. And as we know, evidence taking exercise is probably the most time consuming and the most burdensome in many of the court proceedings, which means that a reasonable limitation of the scope of this evidentiary procedure is also very beneficial. Third advantage, which Jacek has also touched upon, and my understanding is that this will be also covered by one of the panelists, Dr. Grabowski, either today or in a week from now, is the fact that in a general court, which has to handle cases that require very narrow specialized knowledge, you run the risk of some sort of mixing up of the roles of the judge and the expert witness. So you may end up in a situation, which was also mentioned by Jacek, where actually the resolution comes more from the expert witness than from the judge, which then raises additional issues related to how to ensure independence, how to provide all the institutional guarantees that apply to judges but not necessary to expert witnesses, and so on. So the specialization, of course, may kind of like facilitate this, but by reducing the role of, and I'm not saying that we don't want to have expert witnesses. Of course, they may be very useful also for specialized judges. But then the division line between what's up to the judge and what's up to the expert witness can be defined more clearly. And then two additional arguments, which we also see in our practice at the PFSA, because as maybe for the non-Polish participants, one clarification that we at the PFSA, we issue administrative decisions related to the financial market, not only capital markets but also to the other sectors, which then are subject to judicial review by administrative courts, and we don't have a specialized administrative court which would be responsible and competent for matters related to the judiciary control of the KNF, the PFSA decisions, which means that our decisions, when they are challenged in courts, they are reviewed by general administrative courts, and this provides us also with some sort of experience on what are the issues or what are the potential observations that can be relevant for the project of having a specialized capital markets court. And what we see is that the judicial review of administrative decisions is a very formal process, and I can imagine that this applies not only to the review of PFSA decisions, but it may also apply to other disputes related to the operation of capital markets. And the reason for this that I can identify, it's some sort of a behavioral explanation, is that the courts are much more familiar with procedural matters that are general and that are similar, irrespective of the substantive matter of the case. And then the courts are tempted, because this is like natural temptation, like we all do this, to focus on matters where we feel familiar with and where we feel stronger. And that basically means that the courts have a tendency to focus on procedural matters rather than digging into the substantive matter of the case. And of course, this means that sometimes the substantive matter will remain unsolved, and the market won't be provided with authority on this substantive matter that is really at the heart of the dispute. But instead, the court will base its ruling on some procedural matters, like evidentiary matters, or some general matters related to administrative proceedings, or on time limitations that apply in a given case and limit the competence of the financial supervision, for example, and so on. So that this is also related to the fact that if we had a specialized court, I would imagine the people at this court, the judges, to be like very close to the market, and this would provide them with some understanding of what are the currently important issues that are significant for the market. What are the new questions that have a significant impact on the operation on the market? And then I would imagine such a court to be willing to take the opportunities to provide the market with some authority on these issues. Of course, this is also related to like general approach to judicial activism, because you may have you may have different trends. You may have a trend where the court uses procedural regulations or uses procedural arguments to avoid providing the market with authority or to avoid digging into the heart of the dispute. But you may also have an opposite approach where the court shows a more activist position, and then the court tries to use the opportunity to provide the market with authority and to give light to the market, so to say, on what is the judicial approach to the operation on some of the concepts. And what would be my hope related to the operation of a specialized court is that at such a court, judges would be people who live the life of the markets and know what currently puzzles the market in legal terms, what are the issues that require some authority, that require some guidance, and then in case of a given dispute which gives the court a chance to review this matter, this substantive matter, then the court won't hide, so to say, hide behind the veil of some procedural requirements or some procedural questions in order to avoid digging into the matter. But on the opposite, the court will use the opportunity to speak loudly and to provide the general public or the market participants with authority. So these are the arguments that speak, of course, in favor of specialization. And one may say that it's quite difficult or it's hard to imagine a reasonable alternative to specialization. Before moving into more detail, I will briefly refer to some examples that we have seen worldwide. So maybe one general comment is that specialized courts are not that uncommon, because a World Bank's report from 2012 actually shows that specialized courts were established in 23 countries, and it's also one of the IOSCO's recommendations to have specialized courts that will ensure the trust of the market participant in the operation of the market. So it's not that uncommon, it's not that original, and maybe it's something that we should treat rather as some sort of a lag that we have here in Poland. Moving to some prominent examples, of course, one example that I have to mention is of course the Delaware Court of Chancery, which is probably the world's most renowned corporate court. It's not a capital markets court per se, but it's let's say more of a business court. But what I believe to be especially worth mentioning is that actually the quality not only of the Delaware business law, but it's also the quality of the court that has allowed the state of Delaware to become the United States probably one of two or maybe even the most prominent corporate jurisdiction in the states. So this clearly shows how the quality of the adjudication and how the quality of how the business disputes are resolved can contribute to the success of the economy or of the jurisdiction. And this becomes especially true in cases where we have the growing degree of competition between legal systems and between jurisdictions. So that may clearly become a competitive edge for a given jurisdiction. Another example that I would like to mention, which is significantly younger than the Delaware Court, is the Tel Aviv Court. Is the Tel Aviv Court for Securities and Corporate Law. It was established in 2010, and it has proven to be a significant success and a milestone in the development of the Israeli market. So it was described by a prominent Columbia professor, and then who was then appointed as head of the Israeli Securities Market Authority, Professor Zohar Goshen, who mentioned that this is a milestone in the enforcement on the capital market, and the court has proven to be extremely active in providing the market with authority and with interpretation on how some concept should operate, and that's exactly the role that I would hope such a court could fulfill. So to be to be the to be the entity that provides the market with authority. Especially that, as we all know, I mean, at least the lawyers among us, but probably we all feel intuitively that in today's times, with such a fast pace of economic development and fast pace of the development of the market, it's quite natural that the law and regulations that are at least one step behind. I mean, one step probably is a very optimistic diagnosis. Probably there are some steps behind, which means that the law will never be up to date with the current needs and current developments of the market. And then you need to have some sort of gap fillers. And one of the gap fillers is the activism of the judiciary, which will come up with authority, which will come up with interpretation that helps to solve or to fix the gap between what the market needs today and what the law maybe will be able to come up with tomorrow or the day after tomorrow. And actually, this is inevitable, because I cannot imagine a world where the law would try to be before the market in terms of development. So probably this would never work, and this could only have a negative effect on the developments of the market. So this is a natural situation where the law is some steps behind, but that's why you need to have these gap fillers, with one of the gap fillers being the activity of the judiciary. The other gap filler is the activity of supervisors and regulators, like the KNF, where we also have some tools like soft law, where we can react in a swifter manner than the legislator can. But today we are talking about the court, so I just wanted to mention the court activism, the judiciary activism as some sort of a gap filler. And then this brings us also to one question, because probably it's a more question of policy, but I would like to maybe to mention this here. Also, the keynote is also always an opportunity to raise some issues where actually I don't have an answer, but to raise them in order to maybe inspire the discussions in the panels, and then maybe hear at least some potential solutions to this issue. Because the one of the questions, which is a policy question, is that to what extent the financial market, or the capital markets in particular, should rely on public enforcement, and to what extent it should foster private enforcement. One prominent example of a legal system which fosters private enforcement is, of course, the US legal system, with the procedural regulations, because it goes down not only to the capital markets regulations, it's also related to the procedure, to the court procedure, to matters on, for example, to the issue on how the legal system approaches to legal costs, to the cost of proceedings, and so on. So, of course, this requires some coherent approach from the lawmakers. But that's a question which is also related to the question to the discussion on the capital markets court. To what extent we would like private enforcement to become a significant determinant of the operation of the capital markets, or whether we stick with the more traditional approach, with public enforcement being the core. And the Israeli example, that's why I'm mentioning this right now, because it's also related to the Israeli example, because my understanding is that the Israeli example is to some extent at least inspired with the American approach to give more space to private enforcement, because private enforcement has its benefits. It relieves the public administration from some costs, and one may say that plaintiff lawyers act as state attorneys to some extent. But that's a policy choice. So that's a policy choice which has to be taken at a relatively high level, but then of course it may have its impact also on how we view the role of the capital markets court. Because if we go the route of fostering private enforcement, then we also should think of procedural measures or like technical measures that would foster the activity of private plaintiffs. Coming back to the Polish landscape, back in 2019, the Polish Ministry of Justice has appointed a working team, a working group, which has been given the task of coming up with a concept of a court that will be handling capital markets dispute. The matter has been also identified at the level of the Polish governmental strategy for the development of capital markets, which it is a document that has been approved by the Polish government, by the Council of Ministers, and it also points to the dispute resolution in the capital markets as a key area of interest, where dedication of additional efforts and additional resources can increase the trust of the market. And we also absolutely share this view that the trust of the market can be enhanced once disputes related to the operation of capital markets are resolved in a more efficient manner, in a more predictable manner, and in a manner which is in line with the needs and the development of the market. And now I will refer more specifically to some of the assumptions that were provided by the Allerhand Institute in their report on the Specialized Court. And let me start with some general comments. So first, the first general comment is that as regards the composition of such a court, we believe, or I believe, personally, but also my colleagues at the KNF, that the court should be as professional as possible, which means that we are a bit skeptic as far as the appointment of like honorary members or honorary judges is concerned. So we basically believe that maybe they could be appointed to some sort of advisory body to the court, some advisory council, but the judges, I would expect the judges to be like full-time judges dedicated to their professional activity in the court, which means that probably there would be no place for an appointment of honorary members that are that become judges by virtue of their contribution to the development of the market or whatever. So this could be potentially discussed as some sort of, as I said, like a advisory council or like a scientific or academic council of such a court, but the judges should be hands-on, and this should be their sole or main professional activity. Second general comment is that we generally agree with the concept of having an appellate or appeal division in the Court for Capital Markets. So we believe this is a good solution to have the Capital Markets Court being a two-instance court, because this would provide us with the benefits of having the specialization not only in the first instance but also in the second, which is quite natural. The only thing that bothers us a bit or leads to some concerns on our end is that we do not have a uniform appellate procedure that would be applicable for criminal cases and for administrative cases. So this would be like a dual track appellate or appeal process, a different one for the civil cases that will be adjudicated by this court, and a different one for the administrative cases or for the public law cases, which then may cause some issues related to the organization, but secondly also to the competence, because probably not all judges who are competent or who are proficient with administrative appellate procedure are equally competent with civil appellate procedure and so on. So this is probably something that should be then investigated in more detail. This leads me also to one more general comment from the point of view of the financial supervision, because we as the financial supervision authority, we act pursuant to the Polish Code on Administrative Procedure, the KPA is the Polish abbreviation. The more and more the financial market develops, and the more and more this development requires swift responses from the regulator and from the supervisor, we believe that the Code for Administrative Proceeding is becoming like less and less functional from the point of view of our operation. And of course, it is to some extent a controversial thesis, which I will present now, but we believe that generally, in the ideal world, we should not be bound to act pursuant to the administrative proceeding, because we should be heading for some more pragmatic solution that allow for a swifter response and for more efficient and quicker proceedings. The Polish Administrative Proceedings Code is from the 60s. It has been issued in 1960, if I recall correctly. Of course, it has been subject to several amendments, but my personal view is that does not meet the needs of current supervisory work, and does not necessarily respond to the challenges that we see in our supervisory work. So of course, once we make this bold move and we decide that maybe this financial supervision to some extent should be exempted from the administrative proceeding code, then of course it affects also the questions related to the judiciary control. But for the time being, what we believe to be some sort of a question mark related to the appellate procedure in the Capital Markets Court is that actually this would be an appellate procedure which would be then divided into civil appellate procedure and administrative appellate procedure, which may to some extent defeat the purpose of having this in one court. But on the other hand, maybe there's no other better alternative. And the final general comment relates to the criminal cases. We also shared the view presented in the Ireland Institute document that the criminal cases should be left to Court of General Competence. And probably one additional argument that you may use here is the argument related to the equality, because this could be probably constitutionally doubtful whether it's okay to have like a criminal fast track for crimes related to the operation of capital markets with a regular track vis-a-vis regular track for all the other crimes, because then we encounter the issue of having a dual standard of criminal liability and criminal procedure depending on the context of the crime. So probably this would raise additional concerns, but for the time being we believe that it would make sense for this reason also that I mentioned above to leave it to the Court of General Competence. And now moving to more detailed comments, firstly I would like to touch upon the proposal to establish a so-called public division of the Capital Markets Court, and the public division would be competent for the review of administrative decisions of the financial supervision. According to this proposal, the procedure will be structured similarly to the one that we have in connection with the decision of the Polish anti-monopoly office, which is the office for consumer protection and for competition and consumer protection. And in respect of the decision of the Polish anti-monopoly office, there is a special court established in Warsaw, which is competent for the review of the decision in a proceeding which is generally similar or is based on the civil procedure, on the Polish civil procedure. And what is being proposed in the Ireland Institute document is to have a parallel or similar solution applicable for the review of the KNF decision. And then, of course, there are some advantages and some disadvantages. Probably one of the I will start with the disadvantages. One of the disadvantages is that this court will be allowed to take evidence, which we believe it's not necessarily the best solution, because actually the matters that are controversial in cases of our decisions that are brought to court, these are mostly legal matters. It's mostly about legal assessment. So the evidentiary part, probably it's not that relevant like you may see it in antitrust cases or in consumer protection cases, which means that we don't necessarily see a strong argument to allow for evidentiary process at the level of judiciary control of the decision. The other thing that we believe to be a question mark, I'm not saying it's a disadvantage, but it's a question mark, is that what should be the standard of review of the KNF decision? Should it be a more legal standard of review, a more formal standard of review, or should we be heading towards a more substantive review? And that's a question that I will leave open, because I can imagine clear advantages of both solutions, with the formal review being a swifter solution and a quicker one, especially that we have. How many minutes? 2 minutes. Okay, thank you, Adek. So the quicker solution is to limit the judicial review of our decisions to the formal element, especially that we have a two-instance proceeding at the KNF. So the party has the right to have its case re-examined by the KNF itself, and only and after that it can be brought to court. So, yeah, but I can also see arguments speaking in favor of a more substantive review. And then if we decide that the substantive review, the substantive standard of review is a better one, then this would generally support the idea of having a specialized court that would be competent for the review of the KNF decision. Finally, one issue that I have to mention is it is related to the broad remit of the KNF, because we are responsible for the supervision not only of the capital markets but also of the banking sector, of payments, insurance, and so on. Which means that once we decide for a specialized court that will be competent for the review of the KNF decision in the field of capital market, then the question appears: what about with the other? What about the other sectors? Would they be subject to the same review by the same court, or would they be subject to a review by the general administrative courts? Probably the second solution is not the intuitive one, but then it would significantly broaden the remit of the appellate division or the public division of the capital markets court. So these are the questions that I wanted to raise. Moving to the civil division. Probably I have about 1 minute left, which means that I will focus on two matters only. One matter that I would like to raise is that I believe it is a challenge to define the scope of the competence of such a chamber, because it's beyond doubt for us that it would be good to have such a chamber in the Polish legal system, which would be competent for the disputes related to the operation of the capital markets. But then what we see in the market, that we have relatively many cases with many potential plaintiffs, with individual investors, with retail investors, or maybe even not retail, but multiple investors that have been harmed in the financial market. And then the question is how we handle those cases, because it would be a bit counterproductive to have the specialized court clogged with individual cases with a relatively low value. Which means that to move forward with this solution, we have to find procedural solutions in place that will somehow limit the number of cases. So I can imagine this can be handled with a good class action legislation. It can be handled with some sort of, like you have in Germany, the Mustafa-Faden, which means that you have a lead case, and then once the lead case is being resolved, then you resolve all the other cases based on the lead case. I can also imagine some sort of institutional representations of investor, like you have in the bond market, or you have in the fund industry. You have a depository, or you have a bank which operates as a representative of the investors. But then this sort of institutional representation would provide some sort of a bottleneck and would limit the number of cases that would be subject to review within this court. So these are the questions that I would like to raise today. There are many others that probably also require discussions, but given that time, as always, is limited, I'd like to thank you very much for this opportunity to share my thoughts with you. And Adek, thank you very much. So back to Vienna. Over to you, Adek. Thank you very much.
Thank you so much, Jacek, for your presentation and for discussing what is on the table. And you did it in such a way, because this document that you a couple of times referred to is for now only available in Polish, but I think your references made it clear also for international audience what are the key points that we are discussing. And I think many of those, or most of those questions have some universal appeal and are considered and discussed in countries, those that already have those courts, who are ahead of everyone else, and specifically in those countries that are just playing with ideas whether or not to have a court of this type, and if so, what shape should it take. So thank you so much. We will have a round of discussion after the first session. So I would like to announce now a 5 minutes break for our Ernest, who is in charge of putting this all together online, and then we will move on with the first panel, and Pavlos will take over the chair of the first panel. Thank you so much, and we see each other in 5 minutes from now. Thank you.
So good morning again, everyone, and welcome to our very first panel in today's conference on specialized courts. And I have the honor of introducing you to three distinguished speakers from Austria, the Netherlands, and Spain. And I'm going to say a few words in relation to each one of them in turn. So first is Georg Kodek from Austria. Georg has studied law at the University of Vienna and at the Northwestern University School of Law. And in 1991, he was appointed a district court judge in Vienna. After serving at the Superior Court of Eisenstadt and the Vienna Court of Appeals, he was appointed in 2006 at the Austrian Supreme Court. In addition to this, he's professor of civil and commercial law at the University of Economics and Business in Vienna, and he is currently heading there the Department of Private Law. He has published extensively in the fields of civil and commercial law and civil procedural law, and he has also acted in the past as visiting professor in Luxembourg and as visiting scholar in Australia. Since the 1990s, Georg has also served as an expert for the Council of Europe and later for the European Union in former Yugoslavia, Ukraine, and other Central and Eastern European countries. So Georg will be giving to us the Austrian perspective, and subsequently Bastian Kemp is going to provide us with a Dutch perspective. Bastian is professor of corporate governance and corporate regulation at Maastricht University in the Netherlands. And he is also a professorial fellow and vice academic director at the Institute for Corporate Law Governance and Innovation Policies. Bastian is a member of the editorial board of the Dutch corporate law journal Maandblad voor Ondernemingsrecht and is a fellow at the Zaldas Institute of Financial Law and Company Law at the Free University of Amsterdam, and a member of the Corporate Law Advisory Committee of the Dutch Bar Association and the Royal Association of Dutch Civil Law Notaries. Bastian graduated cum laude in 2013 from Maastricht University. He obtained his PhD in 2015 and became part-time assistant professor at Maastricht and the Erasmus School of Law. And he currently works as a corporate lawyer at Loyens & Loeff in Amsterdam alongside his academic function. After Bastian gives us the Dutch perspective on the Enterprise Chamber at Amsterdam, we're going to be welcoming Paula Del Val Talens, who is going to be giving us the Spanish perspective in relation to specialized courts and dispute resolution in Spain. Paula is assistant professor of business law at the University of Valencia in Spain, where she reads economic private law topics ranging from company and capital markets law to EU internal market law. So her scientific work primarily focuses on company and capital markets law, as well as corporate social responsibility, CSR. She currently leads a 2-year research project on cross-border conversion, mergers, and divisions after Directive 2019-21-21 in cooperation with researchers from 7 European countries. So a set of 3 distinguished speakers in this very first panel of our conference today. And I will now give the floor to Professor Georg Kodek, who is going to discuss with us his research on the Austrian experience with specialization in handling corporate, M&A, and capital market disputes. So, Georg, the floor is yours.
Thank you. Good morning, everybody. And thanks, first of all, to the organizers of today's event. My presentation is going to be, as you just heard, about the Austrian experience with specialization in handling corporate M&A and capital market disputes. Now, this is a somewhat cumbersome title. A short version of that title would be the commercial court, or rather plural, the commercial courts in Austria. So I'm going to focus on an old institution which may also be a solution for some modern problems. Obviously, I'm going to focus on Austria since this is a country where I have spent most of my life and certainly most of my professional life. But I will try to look a little bit beyond borders and also try to address some more general, some institutional aspects. Now, let me see whether that remote control works. It seems it does not. So can we have slide number 3, please? Seems we can't, but I fortunately I still belong to a generation. Okay, now it works. Now it does work, which a generation that can also manage without PowerPoint. Now, the tradition of commercial courts in Austria looks back to 300 years, and clearly the commercial courts are of extremely practical importance, but also and that already alludes to the more general point of my short remarks. These courts also are of theoretical importance, because when one talks about commercial courts, one also has to discuss and have in mind some more general aspects, such as the advantages or possible disadvantages of specialization. Can there be over-specialization? Can there be unfortunate or undesired effects of specialization? And on a more general level, can business courts, the very existence of and access to business courts, be an advantage for a country as a business location? Now, let me start with a brief history of commercial courts. And I already mentioned in Austria, they only go back 300 years. When we start with the history of commercial courts, we have to go back to the Middle Ages. And clearly, we have early commercial courts in Italy and later in France. And there, a characteristic feature of these courts was that merchants, business people, businessmen as they were at those times, were sitting as judges. So they were deciding their own disputes. We then have in the early 16th century the Lude commercial court, the first German language commercial court. And in 1807, we have the French Reform, and among the laws enacted by Emperor Napoleon, we have the Commercial Code. Now, interestingly, Napoleon originally was opposed to merchants as judges in commercial courts because he wanted an influence over appointing judges there, but ultimately he retained the French system of having lay people sitting as judges in commercial courts. Now, most German states adopted a mixed system of professional judges and lay judges, commonly having chambers or panels in these courts composed of one professional judge and 2 lay judges. Now, in the 19th century, we find an interesting shift of paradigm, because originally the idea was, let us have merchants decide their own cases. So let us protect class interests of merchants by having merchants as judges. Now, in the 19th century, the idea was different. The focus shifted towards specialization. So the idea of having merchants, business people as judges, was to have people who have special knowledge, special expertise with these types of cases. Now, if we focus on Austria, now in 1508, Emperor Maximilian instituted lay judges in a number of courts, in commercial courts, first in Leipzig and Nuremberg. Now, the building you see on my slide is not obviously the building instituted by Emperor Maximilian, but is the 19th century Vienna commercial court. In 1717, so a little more than 300 years ago, a commercial court was set up in Vienna by the name of Mercantile and Bill of Exchange Court, which had 1 lay judge and 6 assessors with legal training. And above that court, there was an appellate mercantile court, and there was a second appeal authorized to the Emperor's Court, to the Hofkanzlei. Now, in 1861, there was the General Commercial Code adopted by German countries, and that time that included Austria. In 1897, Austria adopted its civil procedure reform, and this reform retained commercial courts in Vienna, but also in Prague and Trieste. Now, as we all know, because of the outcome of World War I, we lost Prague and Trieste and only have a commercial court in Vienna, where the panels are composed of 2 professional judges and 1 lay judge. The lay judge is an experienced businessman. So that's the idea behind this type of courts. Now, let me briefly look to other countries, although we'll have an opportunity today and next week to get more information about some of the countries I mentioned here. I already briefly alluded to Italy and France being the roots of commercial courts. I have mentioned Germany. I should also highlight the 1850 institution of the Hamburg Commercial Court. And nowadays we have specialized commercial panels in Germany within the ordinary Landgerichte, within ordinary regional courts. We have commercial courts in Switzerland in a number of cantons, and there, characteristically, they retain the old notion of having merchants, having business people as judges, so they have lay judges there. In England, or in Great Britain rather, we have commercial courts, but not by that name originally. We have chancery courts, which were instrumental in developing some areas of what nowadays we would call commercial law. And today we have a court which is called exactly that, commercial court, and we have a technology and construction court. And these courts are parts of the Queen's Bench division. If we look to the United States for a few moments, we have chancery courts in some states, and we already had in our keynote speech this morning of the Delaware court, which is instrumental, of course, in the development of company law, particularly corporate law. And in 2012, so only less than 10 years ago, there was a commercial division set up in New York as a division of the New York Supreme Court. Please note that the New York Supreme Court is contrary maybe to what the name suggests to a speaker, to a listener without US legal training. It's not an appellate court, it is a first instance court. So there they set up a specialized commercial division. Now, let me turn now to Austria, my own country. On the slide, you see the what's called Justice Tower in the center of Vienna, which houses the commercial court and also the commercial district court and also the general district court for the center of Vienna. We have a commercial court only in Vienna nowadays, which is a specialized court hearing certain types of disputes, provided the amount in controversy exceeds 15,000 euros. In all other cities, ordinary regional courts sit as commercial courts. Now, there are a number of criteria. There is a long laundry list of cases belonging to the commercial court, but the most important criterion is any case brought against a registered business. So it does not matter who the plaintiff is. If the case is against a registered business, the commercial court has jurisdiction to hear that case. It also hears certain company law disputes, patent law cases, cases involving the commercial register, and a number of other cases. If the amount in controversy is up to 15,000 euros. There is in Vienna a specialized commercial district court located in the same building you see depicted on my slide. And in all other places in Austria, these disputes would be heard by general district courts, which then sit as special commercial district courts. But it would be the very same court that also hears general civil matters. Now, let me now turn to, if the slides work, yes, to who sits in these courts, who are the judges. A lot of things changed from the Middle Ages and also from the 19th century. Nowadays, almost 99% of all cases are decided by a single judge, by a single professional judge. But obviously, this judge has a tremendous expertise in commercial matters because he sits on the Vienna Commercial Court. Only occasionally, we have a panel composed of 2 professional judges, so not 1 but 2, and 1 lay judge who has the honorary title of Kommerzialrat, commercial judge, in cases where the amount in controversy exceeds 100,000 euros, but only if one party so demands, so requests, and that is extremely rare. We only have about 20 such panel decisions in the Vienna Commercial Court every year. Now, when we look at the higher courts, at the Court of Appeals, there is no specialized court as such, but the Vienna Court of Appeals has specialized chambers, specialized panels, normally composed of 2 professional judges and 1 lay judge being an experienced businessman. And at the Supreme Court level, there is no specialized commercial panel, commercial chamber as such, but there are a number of specialized chambers who specialize in areas which constitutes parts of commercial law, such as company law, patent law, unfair business practices, and a number of others. Now, let me turn now to investor cases. Now, why are investor cases brought to the commercial court? And the answer is simple. The very reason is if defendant is a registered business, the commercial court has jurisdiction. Now, that leads, ironically, perhaps, to the Vienna Commercial Court being the biggest consumer court, because many investor cases are brought by consumers. And we had up to 20,000 cases pending, investor cases pending, before the Vienna Commercial Court and Vienna District Commercial Court. Now, clearly, that leads to a very high level of specialization. And to illustrate this factor, there is a summary, very brief summary, on all pertinent Supreme Court decisions somehow affecting investor cases. And this summary alone comprises 300 pages. So that shows the degree of expertise and specialization necessary to decide this very special and very difficult, very complex part of the law. But I do not want to just focus on Austria alone. I want to address briefly a few institutional observations. Now, in Vienna, we have professional judges. As I told you, that's different in some other countries. And our code provides a long list, a fairly detailed list of competencies of these judges. So there is a long laundry list, as it would be called in the United States. When we look at the law applicable to these cases, it's not so much the law in it by itself that makes the cases difficult, but it's the greater complexity of the cases altogether. It may be that expert witnesses are necessary. It may be that we have a larger number of witnesses. It may be just that what the case is about is more difficult than an ordinary run-of-the-mill civil case. Clearly, because Vienna is our biggest city and the Vienna Commercial Court is located here, Vienna is a center of such disputes. And as I already mentioned, the Vienna Commercial Court, perhaps ironically nowadays, is also a consumer court, because it decides investor cases, provided the defendant is a registered business, which very obviously is very often the case. Now, when we look at the contribution of commercial courts to solving modern day problems, we find a number of areas where commercial courts, or the commercial court and the district commercial court were instrumental in paving the way for 20th century and 21st century developments, such as the electronic company register, which was introduced in the 1990s, the Austrian class action, which was introduced in the early 2000s, case management in mass disputes, and perhaps most recently, court-annexed mediation. All these were developed and later on developed further on by the Austrian commercial courts and the judges and working there, and obviously the lawyers representing their clients appearing before these courts. In concluding, I would like to very briefly address some of the pros and cons. And we have already heard in the introduction this morning, obviously there are chances and risks involved when we talk about specialization. If we want to look at the chances, there is a famous quotation I want to share with you by the Chief Judge of the Court of Customs and Patent Appeals in the United States, Howard Markey. And he compared specialized courts to brain surgery. And he said, if I'm doing brain surgery every day in and day out, chances are very good that I will do your brain surgery much quicker, or a number of them, than someone who does brain surgery once every couple of years. So that clearly is an advantage. A possible disadvantage is a kind of tunnel vision that may develop, particularly if the recruitment of the judges comes only from a very small segment of the profession. A possible example of this would be the Austrian tax court, where judges are almost exclusively recruited from the tax authorities, and that may contribute. I do not suggest it always does, but it may contribute to a sometimes one-sided view. So clearly one wishes to avoid that. It is also more difficult to assess the workload. If everybody hears run-of-the-mill cases, it's very easy to compare. You have one divorce or you have one sales contract. But if we compare more complex cases, it's very difficult how many simple cases one would have to hear to make up for one difficult case. And that makes the distribution of the workload sometimes difficult. Also, we have to look at career perspectives. So payment in Austria is the same in all courts, but do we have, or do our judges have some other advantages? What about their career perspective? Do they have a chance of earlier promotion, for example, if they agree to hear more difficult cases for a number of years? It seems the answer was yes a few years ago, and perhaps the perception still is the answer is yes, because there never has been a recruitment problem in the Vienna Commercial Court. Another factor is the esprit de corps, the spirit among these judges. They may tend to perceive themselves as an elite corps of judges, an elite group of judges, and to a certain extent that is a good thing if one does not push it too far, if it does not get into becoming too arrogant and too proud. But being proud of what one does could also be an incentive for maintaining and perhaps even increasing the quality of the services offered by that particular court. And finally, an important point, the quality of the decision, the correctness, the rectitude, if I may use that term, of the decisions, and perhaps what is even more important, the acceptance of these decisions by the community, by the citizens at large, and by the lawyers appearing before the court. That is very important. And we do have empirical data. We have statistics, not for Austria, unfortunately, but for the United States, And there it seems that having the case decided by a specialized panel may contribute to an increased acceptance of the decision. And that clearly is a good thing if the parties accept the decisions not just as some ruling given by a court sitting high up there, by a judge sitting up there very high on a bench, like portrayed in the 19th century by Charles Dickens, but by a tribunal which understands the underlying issues, the underlying particularities, the specificities of the case, of economy, and of everything surrounding the individual case. So on that note, I would like to close my short remarks this morning, and I would like to thank you for your attention. Thank you.
Well, Professor Kodek, thank you very much for this immensely interesting presentation. And I must say that we knew that Vienna is an international center for arbitration, but I personally was not aware that there is also a specialized commercial court based in Vienna, and that I find very interesting. So there is a number of interesting points that you raised, which we will have the opportunity to discuss in the roundtable discussion after the two presentations that lie ahead. So with this, I would like to turn to Bastian Kemp. Bastian, as I understand that what's on the agenda is that you will be discussing the Enterprise Chamber of Amsterdam, the so-called Ondernemingskammer, which is a specialized court for corporate law disputes that has delivered over the years certain very interesting rulings. So the floor is yours, Bastian.
Thank you, Pavlos, and it's great to hear that your Dutch is still very good. So that's good. Let me check whether I can actually push through the slides. I think that's the case. Yes. So what I am going to do in give or take 15 minutes is discuss with you the impact of one particular business court, specialized business court that we have in the Netherlands, which is the Enterprise Chamber of the Amsterdam Court of Appeals. And what I particularly want to discuss with you is why we, at least from a Dutch perspective, feel that this specialized business court is so successful. And as you already mentioned, Pavlos, it has made a number of rulings over the years that have been very fundamental to the way we've structured our corporate law, our business law, and our corporate governance. And as a result of that, you can see that we are also, as a country, developing our corporate law to a large extent by means of rulings from the Enterprise Chamber that, of course, are then, in some instances, confirmed or removed by the Dutch Supreme Court. So what I want to talk about is basically I want to talk about business law from a certain perspective. Which of course fits the Enterprise Chamber, which is when we have a corporate litigation dispute, generally what we see is that parties involved in the dispute want to obtain some type of immediate relief in order to force the opposing party to either perform a certain act or to refrain from performing a certain act. And of course, for a very clear example of that is when you have a 50-50 joint venture. One of the parties, one of the shareholders feels that a certain resolution has to be passed within the company, and the other their joint venture partner is refusing to cooperate in that. And in those type of cases, you would like the court to basically break the deadlock that has arisen within the company by means of giving an order to do something to the joint venture partner. Now, in those types of cases, a claimant generally has two possibilities. Either you use the general injunctive relief proceedings before the relief judge of the district court, which is a proceedings that's open to any party in any type of litigation in which a party would like injunctive relief. So if you have a problem with your neighbor or with one of your employees, you could also go to this court. Or you, as a claimant, choose to go to opt in for the specialized judicial proceedings, which we call inquiry proceedings, before the Enterprise Chamber of the Amsterdam Court of Appeals. And I'm, of course, going to focus specifically on why claimants in business disputes or in corporate governance disputes and corporate law disputes generally tend to go for the specialized judicial proceedings instead of for the general injunctive proceedings, and what the underlying rationale is for that choice, and therefore also for the success of the enterprise chamber. So I want to briefly explain to you what is actually the enterprise chamber and what are inquiry proceedings, because that's the way, or at least one of the ways that you get to the enterprise chamber, and the one that I specifically want to focus on. So inquiry proceedings allow certain interested parties to request an inquiry, so an investigation to a certain extent, into mismanagement in relation to corporate governance issues within the company and its affiliated entities. And next to that, the interested party that makes the claim can also request immediate or definitive measures to be ordered by the court in such situations, which is basically the breaking the deadlock type of order that I just discussed. And these inquiry proceedings have a number of objectives, which I included on the slide. At the end of the day, there are, I think, two types. The first one is to basically recover or restructure the relationship within the company in order to safeguard the interests of the company and the enterprise connected to it. And at the same time, by means of the investigation, it's possible to either obtain information that leads to a potential measure to keep the persons or entities responsible for mismanagement accountable. Now, there are a few characteristics that you need to keep in mind with the enterprise chamber, and specifically with inquiry proceedings, which is it's very much limited to in scope to corporate governance issues, which means that if you have a more contractual claims or claim of a contractual nature or tortious claim, those would typically be inadmissible before the enterprise chamber in inquiry proceedings. However, what we do see in practice a lot is that contractual disputes tend to resolve or also become corporate governance disputes, especially when we're, for instance, talking about shareholder agreements, and therefore you can still basically get your dispute into the enterprise chamber and into the inquiry proceedings, as long as there is a corporate governance angle to it. What inquiry proceedings are very specifically not meant for is to establish damages or to establish a tort. Of course, the report about mismanagement can lead to that conclusion in separate proceedings, but but it's not the goal of the proceedings themselves. And the second thing, which is very interesting, I think, also for this conference, is that the enterprise chamber is a specialized court, and it's composed of 3 judges and 2 experts who are not a member of the judiciary, but do have extensive experience in business or related types of enterprises. And they are typically either experienced, so the laymen basically are typically either experienced accountants, CFOs, or bankers. And this creates an interesting dynamic that you can also see when you're actually arguing before the enterprise chamber, because in front of you, you not only have 3 experienced judges, appeal judges, but next to that, you have 2 experts in business who have a lot of experience and who know a lot about what happens in the boardroom, who are very well aware of how annual accounts work, how the financing of the business works. And that means that also on those items, it's possible to discuss those at a very high level during the hearing, and you will also get very specific questions on that from these experts, and they will also give their input on the judgment itself. So that creates a very, very useful, I think, dynamic for the court to decide on corporate governance or corporate disputes in general, because you have all these different inputs that the court can use in order to come to a solution. And what we generally also tend to see is that the experts ask very different questions than the judges themselves, which for a lawyer in front of the enterprise chamber can sometimes be a bit challenging. But at the end of the day, I think for the outcome of the case, it's definitely a good thing. So, to talk a little bit more about the inquiry proceedings themselves, there is a certain threshold for actually being able to go to the enterprise chamber. I've mentioned them on the on the slide. I think the most important one is that you need to own 10% of the shares, which means that, or at least 10% of the shares, which means that as a small minority shareholder, it's not possible to go to the enterprise chamber. This is slightly different in very large listed companies because we also have a threshold of 22.5 million in nominal value. Then if the company has that nominal value in shares, then you can also, as a 1% shareholder, go to the enterprise chamber. So for the very large listed companies, it's different, but ordinarily speaking, you need to have at least 10% of the shares. And then there are a few other possibilities as well, including the company itself and the trade unions. They can all go to the enterprise chamber and actually do that on occasion, at least. Interestingly, is that we have this threshold to actually get into the proceedings, to be allowed to have jurisdiction there. But at the same time, as soon as these proceedings are launched, any interested party, which is a relatively broad condition, is allowed to join these proceedings by filing their own applications. And they may support or oppose the requests or the original application, and they may also make their own inquiries or ask for their own immediate measures, which creates a very dynamic process and a very flexible process in this type of litigation, because it means that if you have a governance dispute, it's not only the shareholders or the board of directors that can take a position, but it's, for instance, also individual members that can take a position. The works council or trade unions or employees can take a position. Even a financing party of the company could take a position in this litigation, although they generally tend not to do that. But it means that there's a lot of influence from all kinds of stakeholders in the corporation that can join these proceedings and take their own view and make their own requests to the court. Now, because these are inquiry proceedings, as it's in the name itself, there are two phases to these proceedings. The first one is that you make it as an interested party, make an application to the enterprise chamber requesting an inquiry into the policy and affairs of the relevant company. And you can ask for immediate measures. And if the court rules that an inquiry has to take place, only then can it also order immediate measures. And it will appoint an investigator, which is generally a legal scholar or an attorney or a lawyer that will do the investigation. And the investigator has a lot of room to ask questions to the party, to obtain documents, to hold certain hearings. And he will draft an inquiry report, and based on that inquiry report, any interested party can decide to file a basically second phase petition with the enterprise chamber, asking the enterprise chamber to establish that mismanagement has taken place and to order definitive measures such as the removal of certain directors from the company, or even the temporary transfer of shares into the hands of a trustee that will hold the shares for the time being. That also brings me to probably the reason why most parties in the Netherlands actually go to the enterprise chamber in inquiry proceedings, which is the request for immediate measures. It's interesting to note that the enterprise chamber has a lot of room when deciding on what immediate measures to take, and we also know from our foreign colleagues that this is actually quite surprising to many. But the enterprise chamber, basically on the basis of weighing the interests of the parties involved, can take almost any type of immediate measure that it wants to take. There are a few limitations that I've included on the slide, but I want to specifically focus on what is possible. And for instance, what the court regularly does, almost in most cases actually does, where it actually orders interim relief or immediate measures, are appointing independent directors, which may then also have a casting or deciding vote. Suspending directors, suspending the execution or implementation of certain resolutions, for instance, the resolution to call a general meeting or to issue shares to parties, suspend voting rights on shares, or even temporarily transfer shares from a shareholder to a trustee, which means that we also have to explain to parties that are litigating in the Netherlands sometimes that it's possible for the court to, based on one hearing, decide, and the filings of the parties, decide to temporarily take the shares from the individual shareholder and transfer them to a trustee who will then at least temporarily, decide how the rights on the shares should be exercised. It can go even further. We have seen certain cases where the enterprise chamber, for instance, temporarily amends the articles of association of the company in order to make it possible to make certain changes within the organization or within the capital structure of the company. We see that, for instance, in cases of emergency financing, where the company needs additional funds relatively quickly, and one of the shareholders has a blocking vote and is unwilling to cooperate. There we've seen that the court actually sets aside the casting vote or the blocking vote of the individual shareholder in order to make the financing possible. I'm going to skip the duration in the interest of time, but it's basically for the time of the proceedings themselves. What's good to know, and I've shown it briefly on this graph, is that we have had the possibility of inquiry proceedings since the 1970s, so we've introduced them in 1970. However, they've only become more popular and really quite forceful in the development of corporate law since the middle of the 90s, where in 1994 the court got the opportunity to order immediate measures, which was a possibility they did not have before. In 1996, Huub Willems became president of the Enterprise Chamber, and he very proactively activated basically the corporate community and the corporate academic community to start using the Enterprise Chamber for corporate disputes, specifically focused on obtaining immediate relief. And in 1998, the Ordinary Amsterdam Court of Appeals ruled that the Enterprise Chamber takes precedent in cases where basically both the Enterprise Chamber and the relief judge of the district court have jurisdiction to order immediate reliefs, and where parties go to both the instances. So, for instance, one shareholder in the joint venture goes to the district court, the other one goes to the Enterprise Chamber. Then the district court has to say, well, in this case, the Enterprise Chamber takes precedent. So either I don't order any immediate relief, or I order an immediate relief, but only until such a time that the Enterprise Chamber has decided on the case. And in the graph, it only goes to 2008, but you see a very clear rise as of the middle of the 90s. Nowadays, we are, for the last 10 years, it's about 50 to 60 cases each year that are brought before the Enterprise Chamber. So not an extreme amount of cases, but still the Netherlands is not a very large country. And this is, I think, the vast majority of corporate litigation, corporate governance disputes are brought before the Enterprise Chamber instead of for the ordinary court of, or the ordinary relief judge. And that also brings me to my last slide, so which is on why is this specialized court now so successful? Why do we in the Netherlands, why are we happy to it with an extent? I think that has four reasons. First of all, it's a specialized chamber with experienced judges and experts, which means that compared to the relief judge, which sits alone, you here have 5 judges, or at least 3 judges and 2 experts that together decide on the case, which means that you probably also have a more balanced ruling at the end of the day, or at least there's a larger chance of that happening. The inquiry proceedings before the Enterprise Chamber are very, very flexible, as I just discussed. They're also very informal, which means that all the relevant parties can actually put forward their position on what would be in the best interest of the company, how the dispute should be resolved. The Enterprise Chamber has a large amount of tools available to apply far-reaching intervention in order to actually solve the dispute, which means that if you go to the Enterprise Chamber, you will at least know that the Enterprise Chamber could, based on basically on the legal rules in place, could apply the far-reaching intervention that is necessary to solve a dispute. And the Enterprise Chamber is mainly focused on protecting the interests of the company itself, so basically of the target in the litigation, and thereby also takes a less traditional role or less traditional approach to litigation compared to other courts that look far more at the position of the claimant and the position of the defendant, and maybe less at the position of the target itself. And that also, at the same time, explains why the relief proceedings before the relief judge are generally less attractive to the parties. Maybe one last thing to mention is that since the Enterprise Chamber is part of the Amsterdam Court of Appeals, it means you only have one first factual instance instead of two, where in the Netherlands we generally have two, so District Court, Court of Appeal, and then the Supreme Court. Here we only have the Court of Appeal in inquiry proceedings. We only have the Court of Appeal and then the Supreme Court. And before the Supreme Court, you can only ask for basically nullification of the judgment based on either the wrong applicability of the law by the court or insufficient motivation, which, given the very broad discretion of the Enterprise Chamber, is also very difficult to argue before the Supreme Court. So it's a bit like arbitration in the sense that you only get one shot to get it right, which makes it at least more effective in the way that you litigate. And that's it. Pavlos, back to you. Thank you.
Thank you, Bastian. That was very interesting, of course, and it's definitely, the Enterprise Chamber is definitely a very innovative judicial tool that the Netherlands has introduced in comparison to just any other member state of the EU that I'm aware of. So I'm sure that it will be very useful for the attendance of our discussion to get some more insights during the roundtable discussion that will follow. So with this, I will now pass the torch to Paula Del Val-Tallens. I understand, Paula, that you will be discussing the gap between public and private enforcement in listed companies in Spain, which I think is also very topical for a number of other jurisdictions, because that gap does exist elsewhere as well. So I'm looking to hear what the Spanish perspective upon this is, and what remedies perhaps the Spanish legislator has developed in order to close that gap. So Paula, the floor is yours.
Thank you very much. Let's see if I can. Yes. It is with great pleasure that I join the conference today, even in the bitterness of not having been able to join you physically in Vienna. I can only hope for a better chance to do so in the future. And I, of course, wish all the best to the conference next week. I would like to take a brief moment to thank the organizers and hosts for their impeccable efforts. And indeed, my contribution is in line with the rest of the panel, with to explore the interplay between public and private enforcement as regards public listed companies, and specifically as regards corporate governance regulations. By this, I would like to delve into an emerging discussion on whether a gap in the interaction between public and private enforcement exists, and this is whether there is an enforcement deficit, and this would mean that there's an alternative policy framework that we would need to reflect on. Since public listed companies are subject to very different provisions in company law and in financial regulation, as I said, I will specifically focus on provisions regarding to corporate governance, and by these I mean organizational rules regarding the composition of the board of directors, the way in which a company manages her relationships with investors, and also perhaps the way in which directors administer the exercise of shareholders' rights. As you know, typically these provisions are contained in companies' domestic legislation and sometimes arise from EU law. These are harmonized spaces. I will refer to this set of provisions as hard law, but as you all know, their function is reinforced today by soft law, by recommendations that are contained in corporate governance codes, and that typically operate under the comply or explain principle, which means that the public listed company needs to abide to the content of the recommendation or otherwise justify the reasons why they would depart from its content. As a result of that, compliance with corporate governance or even non-compliance is typically reflected on the annual corporate governance report that public listed companies all around continental Europe need to issue on an annual basis. The purpose of the working paper is rather modest. I only intend to contribute to show that such a gap exists indeed, and eventually try to tackle what amendments would be necessary on which of those set of enforcement tools, public or private. However, my purpose today is to briefly cover three main points. The first one would be to discuss why is it relevant from a scientific and practical viewpoint to actually tackle the existence of a gap, and why is Spain a good choice or a feasible option to discuss the issue. And then I will briefly discuss the theoretical framework for both private and public enforcement. Here we see a huge difference, and that is the fact that the literature, scientific evidence is enormous as regards simply consistent with the available evidence. Spain. I've lost, yeah, perfect. As regards to the relevance of the issue, what I see here when I try to tackle the topic from a functional horizontal perspective, what we see is that different European continental jurisdictions have different corporate governance models. And here, the difference that is the most important, I would say, is one that has not been extensively explored and refers to different models of corporate governance codes. Here in continental Europe, we see industry codes, those that are encouraged by public listed companies' representatives themselves, and those that are authored by commissions or agencies attached to the government. That could be attached to a ministry, such as it is the case in Germany, or attached to the National Supervisory Authority for Capital Markets, and that is the case, for instance, in Spain. And my assertion here is that institutional models in countries that have institutional corporate governance codes may be inclined to a stronger public enforcement. That would be specifically the case for systems like Spain, where the National Supervisory Agency authors herself the code and its recommendations and is responsible for the enforcement of the whole, the public enforcement of the whole corporate governance as such. However, as I said, studies regarding the interaction of corporate governance, public enforcement and private enforcement are, to my knowledge, very limited today. If we turn to private enforcement and to the available framework in which we would be able to discuss the issue, we see something that is very well known. With the major corporate governance scandals in the early 2000s, such as Enron or Parmalat, there were enormous calls for more focus on enforcement, but the focus was placed specifically on private enforcement. In this way, for the better part of the last 2 decades, scholarly debate has discussed how private enforcement unfolds in corporate governance in public listed companies in Europe, and has shown what obstacles hurdle actual enforcement within continental Europe. Today, I would only like to point out 3 factors that are probably well known to the audience. European public listed companies are concentrated ownership structures where the majority or the block holders typically hurdle the exercise of such claims, and this is typically related to domestic company law constraints, for instance, the lack of a stand to exercise a claim, or a very high threshold to exercise a minority right. When I refer to these, I refer to claims relating or claims against a resolution of the general meeting or the exercise of a director liability claim, may that be direct or even derivative. And the third factor that the literature has shown is that a certain lack of court specialization is usually attached, or at least not helping the development of private enforcement within all these jurisdictions that have been studied by previous scientific evidence. It is true, however, that in most cases, Spain was not among the chosen jurisdictions, in only one recent exception, a study back from 2020. But when one becomes familiar with the Spanish environment, we see that, like in the rest of continental Europe, claims against resolutions of the general meeting and director liability claims are extremely infrequent. And yet again, Spain is a very concentrated ownership system as regards public listed companies. And whenever we see cases being actually discussed in front of our business courts as regards public listed companies, we see that those cases are what I call strident. This is, they're not representative of the kind of issues that arise within public listed companies on a general basis. There are very exceptional cases. For instance, the ones on the slides refer to the removal of directors that were appointed through our minority designation mechanism, the one we have in Spain under the Companies Act. A competitor was designated by means of this mechanism, and the majority of the general meeting would immediately remove the nominee director of a competitor, and then in every case the removal was deemed by courts justified. So these are strident cases that do not represent the typical issue within a public listed company in any jurisdiction in continental Europe. And the third issue or feature that I would see that makes the Spanish system consistent with the previous evidence is our limited specialization of business courts. Specialized business courts are in place since September 2014, but these are one-level specialization business courts. This means that a Spanish business court holds jurisdiction to decide on all business matters ranging from company and insolvency law to competition and industrial property rights. That is a one-level specialization system, and evidence shows that for actual expertise of business to have an actual outcome on the result of the judiciary decision, we need at least a three-level specialization system. So we would say the level of specialization of Spanish business courts is acceptable, but is not in accordance with what the evidence tells us that would be or would actually have an impact on the outcome. This is not to say that business courts in Spain have not contributed to the development of Spanish company law. They have done so, for instance, as regards the development of the business judgment rule that was indeed developed within business courts in Spain and then codified in 2014. Let me then move, or in the hope that I have shown that private enforcement in public listed companies in Spain and in continental Europe is restricted, generating then the first part of the gap of enforcement. I will then move to public enforcement to try to show that the other set of rules as regards enforcement is equally restricted or limited. The difference here is that we do not have a theoretical framework that is comparable to the one that we explored as regards private enforcement, despite the fact that the framework has been intensively reinforced in the past years, and in spite of the task and the position of the ESMA. However, we see that corporate governance and some specific matters within it, such as non-financial disclosure, are actually supervisory priority areas. So we can expect this to unfold and to be developed within the next few years. If we, in the absence of more evidence, if we take a look at the Spanish example, I would claim that the Spanish model of public enforcement is built on solid stakes because, as I said, we have an institutional model where the NSA, the Comisión Nacional del Mercado de Valores, both authors the code and then enforces it through the supervision of annual corporate governance reports. I would like to briefly comment the way in which our agency actually enforces her powers by pointing out three main ways that are nevertheless very restricted or very limited in practice in the way the agency uses them. The first one are information requests. Whenever this report is not sufficiently clear as regards the reason why a recommendation was not followed, the agency would request clarification. When she is not satisfied with this additional explanations, she will practice the enforcement technique of shaming. This is, she will point out what public listed companies did not abide or did not explain sufficiently in the annual report. However, we see here that the evidence in continental Europe on shaming as a public enforcement tool, specifically in corporate governance, has not been explored very far. I would say that here we see a market enforcement technique being actually applied by a public authority. And I would say that this is worth discussing in the future. And the third possible way of enforcement is one that the agency does not use at all. The Spanish National Authority on Capital Markets rarely, I would say never, imposes sanctions to its public listed companies for the infringement of any provision regarding the annual corporate governance report or the corporate governance report. What we do see are sanctions in this field regarding the non-disclosure of shareholder agreements. In Spain, we have a regime on the transparency of shareholder agreements, a system similar to the Italian model, if you're familiar with that. And that is the only case where the agency does impose sanctions for corporate governance matters, but not in the field of recommendations. What is lacking in the European literature is a full explanation on why that would be the case. To finish my presentation, I would like to briefly point two reasons. One, I believe it to be the continuous use of the comply or explain principle that we see, for instance, in the Shareholders' Rights Directive. We see it in the Non-Financial Reporting Directive. And this technique is essentially a nudging one, but not a sanctioning one. So pushing it forward would oppose actually promoting or encouraging sanctions by NSAs. And the second reason, and this is my final point, would be something like a protectionist regulatory capture on the part of agencies that, to my knowledge, has also not been explored in this area, but only in other very close fields such as the banking union. With this, I just simply wanted to show you what this gap on the enforcement in public listed companies seems to be, at least to my understanding. And I would like to finish here my presentation and hand the floor over back. Thank you.
Well, thank you, Paula. That was very interesting, and it kind of complements with what our other two speakers were discussing before, that the setting up of specialized courts was sought by legislators in order to make up for the fact that perhaps in many instances private enforcement is not sufficient. It is, of course, a very effective mechanism, especially for listed companies, If the share price goes down, this is a disciplining mechanism, but at times we do need stakeholders to be able to seek specific remedies in court that are enforceable. So with this, I would like to officially launch our roundtable discussion, where Jacek is also going to partake, who was our keynote speaker for today. So let me first say that any attendants may type questions that they have or remarks that they have and they wish to be addressed in the roundtable discussion in Facebook, if they're watching over Facebook, and we will make sure to pick these questions up and try to address them. But before this, let me begin with a question to Professor Kodek. It was with great interest that we saw that Vienna has a specialized commercial court, and I understand that this court has jurisdiction not only over corporate disputes, as is the case with the Enterprise Chamber in the Netherlands, but over any commercial law dispute. And my question then would be, if we are to juxtapose this to the Dutch case, the Netherlands has recently introduced the Netherlands Commercial Court, which is a court that can rule over commercial law disputes, as I understand is the case with the Vienna court, but proceedings can be conducted entirely in English. So my question to you is whether you see an option in Austria that the parties can have proceedings before the commercial court, or perhaps a section thereof in English, whether this is something that is being currently discussed. And if yes, how would you see that development in terms of what is at stake in commercial disputes?
Thank you. The answer to your question is yes. This is a thing that is currently discussed. And in Germany, we have already a few commercial courts which offer proceedings in English. And we also had a suggestion a few years ago made by the Chamber of Lawyers, by the Bar Association, to introduce a similar system in Austria in order to attract high-profile cases to Austria and perhaps to Vienna, and to open a business opportunity probably for Austrian lawyers as well, and maybe for restaurants and hotels and other incidental industries involved in big litigation when you bring a lot of people here. Currently, there is no institutional basis for this. So clearly, there are cases where occasionally judges conduct parts of hearings in English, but they would not write the decision in English. I remember when I was a young judge as early as 1991, I held a trial in English with the consent of the parties, but there was no statutory basis for this. So the discussion is, should we introduce something like that? And would it be an advantage for Vienna or for Austria as a whole, as a place of business, if international companies know if a controversy arose, they would have the opportunity to have that case decided in a language which they are comfortable with. So it is being discussed, but no decision has been reached yet.
Thank you, Professor Kodek. And I am having a question from one of the attendants that is addressed to you in relation to lay judges. The question is, what is their profile? How are they selected? I mean, is there a pool of candidates that courts regularly draw upon to have lay judges on the bench, or there just anyone could act as a lay judge in relation to commercial cases?
Yes, thank you. There is a pool, but first they have to be appointed. And they are appointed by the Minister of Justice. And the idea is to have people with considerable expertise in business. And also ideally to have people with expertise from different areas of business. And then they are appointed and have that honorary title of commercial judge, which in Austria, in a former monarchy, a country where people still are fond of titles, is important. So it's not the remuneration, it's the title that makes that position attractive. And then occasionally they sit, as I mentioned, nowadays they do not sit very often, because the Vienna Commercial Court would only have somewhere between maybe 15 and 30, so 30 cases per year where a full panel of 2 professional judges and 1 lay judge would sit. On the Vienna Court of Appeals, the figure is clearly higher, because in all commercial cases they decide by a panel of 3 judges, one of whom is an experienced businessman. So that gives us an opportunity to bring in experienced people having inside knowledge, having insights in a business, and that clearly is valuable, particularly in competition cases, in cartel cases. There we have specialized panels composed of 2 judges, 2 professional judges, and 2 lay judges. And even at the Supreme Court, that is an exception, a fundamental exception. We have 3 professional judges and 2 lay judges in competition law cases. And the lay judges there bring in tremendous expertise. They are selected by the Chamber of Commerce and the Labor Chamber, respectively. And they are cartel law experts. And they bring in tremendous expertise. And I am sitting in this panel, and from January 1st next year, I'll be presiding this competition law panel, and I enjoy working with them tremendously. So clearly, in areas where special expertise is required or even helpful, it's clearly a good idea to bring in this additional expertise, which a professional judge who has always worked just as a lawyer can never have.
Thank you, Professor Kodek. That's a very interesting insight. And indeed, I'm aware of a number of jurisdictions where competition commissions act as judicial organs, at least at the first instance. And there it is almost given that you will have non-lawyers participate who are instrumental in order for an award to be delivered. And with this, I would like to address a similar question to Bastian. Bastian, what is the composition of the Enterprise Chamber? I mean, do we have professional judges there? Do we have former practitioners, or can people that sit on the Enterprise Chamber can currently do other things outside the court? Why is it that it has become so popular? Could it be something not so much in relation to its powers, but in relation to the composition thereof?
Yeah, thank you, Pavlos. That's a very good question. So, in the Netherlands, we have a long tradition of judges being judges for a long time. So we don't have that many practitioners that also become a judge, or at a later stage of their career become a judge. We do have at the Enterprise Chamber. It's a relatively prestigious position, which means that good judges tend to want to take that position, especially the position of chairman of the Enterprise Chamber, which means that they have a high level of skill and expertise. And in addition to that, so that's for the judges themselves. The judges themselves generally don't have too many auxiliary activities. They could be, for instance, an arbitrator in some types of situations. They do that next to their work as a judge, but other than that, it's relatively minor. We do see that the judges try also to be active within the corporate litigation and corporate academic world. So they tend to publish, they tend to be part of associations or even board members of those associations. So in that sense, they are very close to the practice that they see in front of them every day. And in addition to that, for the layman judges, so for the experts, I think it's similar to what we've heard about Austria. It's not so much the pay that's interesting for these people. It's more the work itself that they are allowed to do, and the position that's relatively prestigious and interesting to have. So I think it's a combination of that, and as a result, you also get from the experts, you get people with high expertise that are very good at what they do. And I think I mentioned very briefly during the presentation that the judges themselves, or one particular judge they're also very proactive about telling the community what's possible within their court. And that also makes that they really invite almost the attorneys to bring cases that are interesting to their court, which means that as a result, and that's also, I think, one of the reasons that they're so popular, and that people like to bring cases there because they know who the judges will be. They know they're very experienced and well-reasoned and have a high level of expertise. So that all contributes to the fact that this is such a popular business court.
Thank you, Bastian. Let me now turn to Paula. So Paula, I understand from your presentation that currently there is no specialized corporate court in Spain, but that it seems to me that there might be demand for it. To what extent do you think that Spain is close to introducing, setting up a specialized court? And do you see interest groups from the industry or listed companies lobbying towards this direction? Is there an appetite by the Spanish government to compete with arbitral venues, local arbitral venues, so that parties can refer their cases to state litigation over arbitration?
Thank you. You did understand correctly. We have one level specialized business courts, meaning that they hold jurisdiction for all of the matters that I mentioned before, including company law. So this may range to up to 10 to 12 different matters. So no specific corporate court. And to my knowledge, at least, no pressure today to the enactment or creation of specific company courts or capital markets courts. I was listening to the first presentation, to the keynote speech regarding this idea of creating even further specialization at the administrative level. So establishing whether public enforcement is reviewed in front of an administrative court to create a sort of specialization there. And I found that extremely interesting, but I see no evidence of pressure in that regard. Maybe it's important to note that Spanish courts are also among the slowest within continental Europe. I think only followed or only after Italy. And to my knowledge, the priority would be placed in trying to accelerate the overall result, but not to this day try to narrow down the scope of authority or jurisdiction to specific matters. Also, I believe that study from 2020, where Professor Gelter authored Chapter 3, did place a focus on how Spain, together with Brazil, was one of the jurisdictions that encouraged the most arbitration in company law and specifically in publicly listed companies. So maybe that's one way to go there.
Thank you, Paula. Just one remark. You said that the Spanish courts, they lag only behind Italy in terms of how quick they are. I think you forget to put Greece into the equation here. Someone who litigates before Greek courts, I must say that we are encountering the same challenge over the years. And let me now turn to Jacek. I did listen with great interest to the idea of a capital markets court in Poland. And I would like to discuss with you what has been discussed with Professor Kodek a few minutes ago. Assuming that this idea materializes, how likely you think it is that this court is going to allow proceedings to be conducted in English and potentially to have lawyers that are admitted outside Poland be able to litigate before such court? I mean, I think that if the idea of a capital markets court is an instrument to attract investment, and that could also result in law firms, international law firms, wanting to set up offices in Warsaw or elsewhere in Poland. So do you think that constitutionally or from the institutional framework it would be possible to have proceedings in English in Poland? And do you think that foreign lawyers can be admitted to practice before this court?
Okay, so thank you very much for these questions, Pavlos. So first of all, maybe it's fair to say that the discussions on the capital markets court in Poland, they are at a pretty early stage. I would say it's a conceptual stage. So we have the paper that was prepared by Ararat Institute under the supervision or lead of ADEC. But there is nothing that we can view as some sort of a legislative proposal or a more structured vision of this court. So this is like a general disclaimer. And moving to the language issue. Of course, this may be a valid question, especially given that the knowledge, like the general knowledge of Polish language, is probably not comparable to this of German that you have in Austria, and probably Polish is one of the most difficult languages to learn for a foreigner as well. But personally, I haven't heard of an idea to allow proceedings in foreign languages in Polish state courts. What I believe here to be the key factor is like first is the, like, let's say, constitutional framework connected to the right to justice and so on, which means that probably this could be only possible upon mutual understanding of the parties. So no one can be forced to have their case heard and reviewed in a different language than Polish. That's what I would believe. But the question is whether the parties can decide by mutual understanding to opt for a different language of proceedings. To my best knowledge, and this is similar to what Professor Kodek said before, that there is no statutory basis for such a solution, and this means probably that for example, the court ruling, the decision, and the other ancillary decisions of the courts, they have to be done in Polish. Whether it can be whether the evidentiary proceeding or the pleadings, whether this can be done in English, probably this is something that I can imagine more. So this is something that I consider more realistic. But for the time being, to be honest, it appears to me to be a quite remote perspective in terms of timing, but also in terms of, let's say, the approach. But what I believe here to be the relevant factor is what would be the composition of the courts. Because during my keynote speech, I said that I'm a bit skeptical as towards the honorary members are concerned, or some laymen are concerned. But it's not the case that I'm opposed to having people from the industry being on the bench of this court. On the opposite, I believe that the natural source of potential judges should be lawyers who are also involved, let's say, on the business side of the market. The point that I wanted to make is that what I believe would be beneficial for this court is that the job with the court, or the engagement with the court, should be like maybe not the sole, because I can imagine maybe some side activities, but I believe that this would be the core activity or the main activity of these individuals that would be the judges. So as to avoid a situation where you have judges or lay judges who treat this as some sort of additional activity and are generally active as commercial lawyers or as arbitrators or doing something else, but consider this like an after-hours job to be sitting on the bench of this court. So that I'm not the big supporter of. But what I believe is that if we go the route of having people from the industry joining this court as full-time judges of the capital markets court, then this would clearly also support the idea of allowing foreign languages as proceeding languages in this court. So the more we open the recruitment process of potential judges for people from the market, ex-attorneys, ex-in-house lawyers, ex-investment bankers with some legal, let's say, interest, then the higher the chances of allowing the foreign language as a language of proceedings. But as I said in the very beginning, we are at a very early stage, and for the time being, for me, it's quite difficult to imagine a state court operating in a foreign language.
Thank you, Jacek. That's very very insightful comment you made. We have, I think, 2 minutes left, taking into account that we commenced with a few minutes delay, and I would like to open a question to everyone, to anyone who wishes to respond in the panel. We are at the moment entertaining the idea of launching in a number of jurisdictions specialized courts, possibly courts that can adjudicate in English. We've been informed that Germany already has this, the Netherlands, we know it has. To what extent, and that again is up to anyone to respond, to what extent do you think that it is likely that in the near future we'll be seeing regulatory competition among member states in the EU to attract litigation, to attract the referral of cases into its court? We've seen regulatory competition ensuing in relation to incorporations. How likely is it that member states will, in the near future, compete to attract litigation and to be known as commercial or corporate litigation venues?
I think it's already happening. We see a number of prominent cases being filed in the United Kingdom or in the Netherlands or in the United States. And there, some lawyers very actively work on attracting international business, international cases, and bringing these cases in their respective countries. So I know of a number of mass claims being brought in the Netherlands where the plaintiffs, the original plaintiffs, or the victims of the tort are people from Germany and Austria. So that clearly is already happening now. And if a country has an attractive procedure, has an attractive venue, then that also is noticed by the international legal community and does work to attract litigation and high-profile cases. And I think that development is very likely to increase. And having English language courts in non-English speaking countries is part of that development.
Thank you, Professor Kodek. Would anyone else like to comment on this? I mean, Bastian, being from one of the countries that has an English-speaking court, what do you think?
Yeah, no, I can only agree with George. I think it's absolutely correct. So especially in class action type of litigation, you already see a lot of competition, where the Netherlands is also taking a very, or at least certain attorneys in the Netherlands are already taking a very proactive stance. I think you will see that most of those cases aren't actually litigated in the English-speaking court, so in the Dutch commercial court, because in order to come to the Dutch commercial court, you need the approval of all parties involved, which is generally difficult to get by the time that everyone's fighting with each other. I think if you want to look at regulatory competition between courts, it's probably that the regulatory competition will be more from a material law point of view than from a procedural law point of view, or at least purely procedural in the sense of whether you can speak English, whether you can set the timing of the steps in the litigation yourself. I think it's more of a question, can I go to this court? To what extent can this court issue a binding ruling for all citizens in the EU? Those are, I think, the main items that parties and their attorneys are looking for when determining which jurisdiction they go to. And the language of the litigation itself is slightly less relevant. We see that the Dutch commercial courts, so where you can litigate in English, it doesn't have that many cases yet. It has been around for, I think, 2 or 3 years, but it has a relatively limited amount of cases, and a lot of these large cases are still just going to the ordinary courts.
Thank you, Bastian. So I think we've run out of time. We could, continue for at least another hour or a few hours discussing this. I think it's very interesting, all the insights that have been shared in this panel. So I would like to thank all panelists and our keynote speaker for participating in today's morning session. And I would also like to thank the attendants for taking time off their busy schedules to listen to this discussion. And I'm hoping that next week, indeed, Austria will go out of lockdown and there can be some interesting discussions on site at the Polish Academy of Sciences. So thank you all again for this interesting session. And I guess we're now holding our first break for the day, and we will resume in 20 minutes from now for the second panel.
Thank you.
Hello, good afternoon, ladies and gentlemen, and welcome back to our conference. The afternoon, I have the pleasure to moderate this, and I will start off by introducing the participants. We will have 4 presentations, and the first one will be about the judicial enforcement of capital markets law in the context of initial public offerings, and it will be presented by Barbara de la Vega Justrivo, who is an associate professor of commercial law at the Universidad Carlos III de Madrid, and where she has also a I3 certificate from the Ministry for Outstanding Research. As all of our presentation, Barbara, of course, has an outstanding publication record, which I will not repeat with any of the 5 people I will present now. But let me just continue by saying that Barbara has a law degree with a specialization in European law and also European doctorate, apart from various master degrees from international universities. Her areas of specialization are, on the one hand, something we Austrians don't know a lot about, that is maritime law, contracts, insolvency law, and corporate social responsibility. And she's also been working as an experience as a lawyer and as a substitute magistrate, and advising the Spanish Ministry in legislation as well. So then after Barbara, we will turn to Piotr Stanislavzins, who is Associate Professor in Financial Law at the Faculty of Law and Administration of the University of Opole, and who will be talking to us about the capital market court in Poland, about its risks, but hopefully also about a lot of opportunities such an institution may provide. Piotr is also judge at the regional court in Opole and is founder and chief executive of the Association of Financial Law, Austrian. And then after Piotr, we will turn to Maria. And Maria Domina will tell us about the French Financial Markets Authority and the need for a harmonized approach. And Maria is associate professor at the University of Lorraine in France, holds a postgraduate degree from the University of Manchester and a postgraduate from Strasbourg in her PhD she has done in Strasbourg, France. And she was a visiting researcher at various international institutions, among them the University of Oxford and the MPI in Luxembourg. And she's interested especially in comparative law, financial law, and corporate law. And then last, but of course by no means least, we will turn to sustainability disclosure. Sustainability disclosure and the role of specialized courts in this area. It's a bird's eye view. We're going to get over an institutional problem and its possible solution. And this bird's eye view will be given by 2 presenters, namely, first of all, by Dr. Alperen Götzlügel, who is an assistant professor in law and finance at the Leibniz Institute for Financial Research, SAFE, in Frankfurt, Germany. And Alperen holds a PhD from the University of Hamburg and a graduate degree from the University of Cambridge, also with various positions, among them at the MPI, but this time in Hamburg, not in Luxembourg. Your research interests, Alperen, include comparative corporate law and governance, capital markets law, and financial regulation. And you will be doing that presentation together with Casimiro Nigro, who is a law and finance assistant professor at the Center for Advanced Studies on the Foundations of Law and Finance at Goethe University, which is the Frankfurt University. Casimiro holds a PhD from Luis Guido Carli in Rome and an LLM from the LSE in London. And Casimiro, you are also a visiting scholar at Bocconi, and your research focuses, if I understand it correctly, on corporate law and governance, particularly as regards takeover regulation, which is a hobby horse of mine, and private equity and venture capital-backed firms, and also obviously securities regulation, which you can't avoid in this field. And before joining academia, Casimiro has been working as off counsel for international law firms, specializing in corporate law. Well, this has been a long introduction for a prominent list of scholars. So I just suggest we delve into it, and I would kindly ask you, Barbara, to please start and give us insights into the judicial enforcement of capital market law in the context of IPOs. The floor is yours, Barbara.
Thank you very much, Mr. Winner. I want to thank the organizers for the kind invitation to participate and for the great effort to hold the conference, not on site in my case, but online. The important thing is we are here, so let's go. Well, judicial enforcement of capital markets legislation in the context of IPOs is a highly topical issue that is constantly evolving. In particular, here, the institutional dimension of the Spanish Supreme Court is considered. I have to point out that this work is still in progress, so I can only raise a few issues. However, the content will be developed further in a forthcoming publication. My contribution deals into the question of how application of capital markets legislation in the context of IPOs is giving rise to new interpretations by Spanish Supreme Court on the role of judges in dealing with incorrect information in the prospectus and the trading of financial instruments. The Spanish perspective is dual. On the one hand, there is a contractual aspect of the problem, and on the other, the one that refers to securities market law in strict sense. The topic was addressed by one of the Supreme Court judges, his name is José Vela Torres, at the International Seminar on Social and Corporate Responsibility organized by my university, Universidad Carlos III de Madrid, last November. Undoubtedly, the analysis of the Supreme Court's rulings on important aspects of capital markets legislation allows us to affirm that the institutional dimension of Supreme Court is of transcendental importance in closing the justice gap in investors' protection. It is not exaggeration to say that this issue has, for judicial purposes, revolutionized the mindset of the courts with regard to the approach to contractual consent. In order to analyze the role of the Spanish Supreme Court, this research has been divided in two parts. First, the situation prior to the Markets in Financial Instruments Directive, MiFID I, regulations, and the second, the incorporation of MiFID I regulations into Spanish law. All this in order to study the assessment of suitability and the products or services to which MiFID I regulations apply. In application of the aforementioned regulations, 6 judgments have been compiled that constitute Supreme Court case law from 24 to 28. In terms of the assessment, suitability, and appropriateness and reporting to clients, two tests are applied. Under the first test, the suitability test, where the service provided is a service other than investment advice or discretionary portfolio management, and provided that it relates to complex instruments, the financial institution must obtain information on the knowledge and experience in the field of investment in relation to the product or service offered or requested by the clients. Second, as regards to appropriateness test, where the service provided is a service other than investment advice or discretionary portfolio management, and provided that it relates to complex instruments, the financial institution must obtain information on the knowledge and experience in the investment field in relation to the product or service offered or requested by customers. Regarding the assessment service, the Court of Justice of the European Union, judgment of 30 May 2023 year, yes, case 604/11, has declared that a specific contract is not necessary. It is sufficient to offer the client a financial investment product in a personalized manner. Well, here, the Spanish Supreme Court has taken a step towards closing the justice gap in investor protection. It is a matter of assigning a relative value to the test. Two sentences are example of this relative value to the test. The first, in 2016 year, the Supreme Court failure to comply with the duty to carry out the test does not in itself determine the nullity of the contract, but allows the presumption of error. Another example is the Supreme Court plenary ruling in 2018, and the Supreme Court stated that the practice of suitability test and the signing of the predisposed document on the suitable result of the test does not exempt the entity from the exact fulfillment of its duties of information on the risks. A further issue on which Spanish Supreme Court has established case law on the MiFID regulation is the relevance of lack of information to the client on vitiated consent or error. In this line, some of the rules established by the Supreme Court are: the absence of adequate information does not in itself determine the existence of the defective error, but it does allow it to be presumed. Other rule is that in this type of contract, the firm providing investment services has a duty to inform and to do so sufficiently in advance. Another clear, correct, accurate and sufficient information about the investment product or service and its risks must be provided by the investment firm to the potential non-professional client when promoting or offering the service or product sufficiently in advance of the moment at which consent is given so that the latter can be properly formed. And the last one rule is the failure of the investment services institution to comply with the standard of information on the characteristics of the investments it was offering to its client, and specifically on the circumstances determining the risk. All this means that the client's error is excusable. In addition to the above rules, the Supreme Court has also ruled on public offers of acquisition of shares, IPOs. This regulation is contained in the directive known for everybody on prospectus when securities are offered to the public or admitted to trading. Also in Articles 25 to 30 bis of Ley de Mercado de Valores, Spanish law, and in the regulation on prospectus to be published when securities are offered to public or admitted to trading on a regulated market. This regulation is not yet implemented by the Supreme Court here in Spain. However, the implementation on the regulation has raised several problems. One of them is the institutional investor problem. In December 2019, the Supreme Court questioned whether prospectus liability protects only retail investors or also qualified investors, and whether a possible source of information outside the prospectus can be taken into account. This is an autonomous concept of union law, and then the Supreme Court asked for preliminary ruling in which it asked two questions: whether it also protects large investors, and if so, whether it can be taken into account the large investors can be informed by other means than the prospectus. And the Court of Justice of the European Union answered in affirmative. The European Court stated in its judgment last June that in the case of a public offer for subscription of shares addressed to both retail investors and qualified investors, the action for liability for information contained in the prospectus does not cover only retail investors, but also qualified investors. And second, the judge may take into consideration that the investor was or should have been aware of the economic situation of the issuer of the public offer for subscription of shares on the basis of his relations with the issuer and outside the prospectus. Now, in the light of the European Court's ruling, the Spanish Supreme Court is due to hand down its pending judgment next week on 16 December. This will be the last step towards closing the justice gap in the investor protection by the Spanish Supreme Court. I hope I have provided an insight into the way in which the courts in Spain are enforcing capital markets legislation in the context of IPOs. Thank you.
using phone. Mr. Martin, the phone. We didn't hear you.
Sure. Sorry about that.
Oh,
Typical one.
okay.
Thank you very much, Barbara, for your presentation of the judicial practice in Spain on IPOs and on MiFID. I suggest we keep our questions. We certainly have. We collect them and do the Q&A session at the end of the 4 presentations. And hence, I suggest we turn immediately to Piotr and to the Capital Market Court in Poland and its risks and opportunities. Piotr, the floor is yours, please.
Thank you very much. Welcome. I'm very happy to take part of the conference. Thank you, our chairman, Marcin Wiener, for the nice words on the beginning of our panel. It's nice to see Maria, Altoren, Casimiro, and Barbara, of course. And I want to say to Professor Radwan, good job. Thank you for the Olga and our technical staff that we can take part and all going well. I would like to show the few thoughts, direction about the problem we are Poland for a few years. It's the Specialized Court, a capital market court in Poland, because we still having nothing about the court. I think that is a problem about the constitutional law, the financial law, and also commercial and the civil law. But on the first, I would like to introduction to the Polish justice system, to show what is background about the court in Poland. So let me show the first. In Poland, right now we have the Polish system based on the ordinary district court and the regional courts and courts of appeal. This is civil and criminal cases. So there is a 19% all the cases in the Poland's justice system. In the other way, we have administrative courts and the Supreme Administrative Court. And this is a cases public authorities versus citizen. This is administrative courts deal with the cases in the field of the financial market, including financial supervision and applied administration procedure. There is an act of 1960. It's not mistake. There is a very old act, and I think this is uncomfortable to use in the market and the financial law, and also with the future capital market court. So in this way, we have to use the principle of the 2 instances, the constitutional rule in Poland. And in the organization of the Polish justice system, a few years ago, to start special courts. For example, we have special intellectual property courts, and also we have public procurement special court. And the first experience is very good. This court is quickly, the specialized knowledge, the specialized judgment, and the cases in this court are very, very close to the knowing and of the citizen, also of the part of this case. The next I hope it's going to be okay. So this is the beginning of our thinking and about our direction in the Poland, because currently work on the court of the capital market in Poland at the beginning. 2 years ago, we have a very good conference in Warsaw, prepared, of course, Professor Radwan and also with the Krzysztof Grabowski. Professor Jastrzębski also take part with this conference, and the conclusion was that maybe in 2-3 years in Poland we start with the capital market court. Now we have three years. After 3 years, we are still in the same place. We have nothing, and so our fate is Professor Radwan to steal publication and make new scientist articles about the Polish market court. So we still on the science platforms, not on the practice. So we start talking about it in the conferences. So after 3 years, we have a brief mention of the documents called Capital Market Development Strategy in Poland. Is a document who prepare Polish financial authorities and Polish government as the way to the development of the Polish market, capital market in Poland. And this document, something about 100 pages, is only maybe half page about the future capital market court. So I think that everybody in Poland everybody in Poland talking about the future court, but we are still in the same place as 3 years ago, and it's not good perspective for us. So this conference for me, and I hope that for the others participants in Poland, is the occasion to look at experience of other countries, because direction of solution in the Spain, maybe in Austria, in Germany, and the Netherlands is the way which Poland or the Polish regulation will go. I hope we best solution take place to the Poland, and we are prepared for the Polish market. In this, we have a few areas of the problems I see right now from the start and make the capital court for Poland. For example, system of the capital market court, common court versus administrative court. We have to explain the constitutional principle of 2 instances and speed of proceeding. As of course, we have to prepare the special court area of the whole country. I suppose that headquarters will be Warsaw, plus the entire infrastructure for prepare the court. Okay, of course, it's the technical, but it's also very important for the start and the work of this court. Special court only functionally with the ordinary courts. I think that with the not administrative court, not common court, not civil and commercial court, but I think that maybe it's only functional in the ordinary courts, but with high autonomy for the, of course, judge, for the director and president of this court. But I think it's something between common court and administrative court. Is the third way. I suppose it will be the best solution, of course, but it will be in practice to prepare. I hope the discussion will be very, very hot. So I think that something take part from the administrative court, some from common court. It will be the best solution. Of course, I know that the discussion will be very, very hard, because the next area the process of selection judge of the Capital Market Court, organization and the model of operation of the Capital Market Court. Technical aspect is very important, but I think that the most important in this process to prepare the Capital Market Court in Poland is, of course, people, personnel, qualification for judges. Maybe something like mixed financial market practitioners, arbiters, maybe people of science. I'm not sure that will be more people of science or more practitioners. I think that the same people from the other way have a good solution. Of course, in Poland, because you know to prepare and build the Capital Market Court, it costs. So discussion will be also about number of judge at the first instance and the second instance. Expectation. This is the constitutional rule. I think that something about 10 judges on the first and something about 5, 6 judges on the second instance is enough. We have our experience that is more people that the decision of the court will be different, and market doesn't like this situation. And of course, we have also look at the supervision of the capital. I suppose that we of decision and not a role. This is the proposition for we have important. What the problem is? One moment. Okay. The next area of our beginning is proceeding before the Capital Market Court. The most important role is the financial market is the function of time and money. So we have to, in the other one way, in the other way, we have to respect a party's right so fair and efficient trial. So we have a few ways. Administrative procedure, I think that's very formalized and it's not work good. Commercial civil procedure, I think that indicates to the extension of the market. So I think that the best way will be separate procedure for the Capital Market Court, something like mixed administrative and commercial civil procedure. But of course, is still project or the direction of my, in my opinion. But never mind, this is separate procedure or the mix. I think that we have to know cases involving consumers because it's not the Capital Market Court, and the no cases of crime in the financial market. I think it will be still on the criminal court. And the next area is enforceability and effectiveness on decision in the Capital Market Court. The court will only fulfill its role when the decision will be not only quick, but it will be enforceable and felt. Of course, the inventability of the effects of the settlement, and I think the financial penalties is also personal penalties, ban on practicing the profession or suspension of license. I think it's the all areas I show in the pressure of time. There is a way, direction in the process to prepare and start the capital market court. So let me go to our conclusion. Of course, is my conclusion, not the conclusion general in Poland. As I said, is Professor Radwan also is a leader of the prepared this idea. I think, excuse me, Poland is the scope of the capital market court for the capital market, formulates only the first assumption and creates the theoretical foundation. I think the purpose of the capital market court must necessarily arise. For me, is natural. I think it will be cooperate joint work of science, financial market participants, financial supervision, and justice. I think this mix will be good. The time period, I hope, will be 23-25 necessary to create an environment for the capital market court. And the capital market court, in my opinion, will be essential element of the growth and importance of the financial market in Poland. So I think it's all prepared for our conference, our meeting. Of course, it's only a few areas, but I think it's the necessary, and if we choose the best way to the growth and to prepare the capital market court in Poland with the experience of other countries, we should and we have to prepare good solution, good court for the growth of the financial market in Poland. Thank you very much. I apologize for my English, but last few years I don't remember that I used the English for the science conference. Thank you very much.
Thank you very much, Piotr, for your interesting presentation of the plans. I've jotted down a number of questions I may have at a later stage, and I suggest those listening in do the same. So, but now I'd say we turn from the project of a new institution to one institution which already has existed for a considerable time, namely the French AMF. And we will now listen to Maria Domina about the need for a harmonized approach. Please, Maria, the floor is yours.
Thank you very much. Dear colleagues, my name is Maria Domina, and I'm assistant professor in business law at the University of Lorraine. And first of all, I'd like to thank the organizational committee of this conference to invite me here today and to give me an opportunity to present my research on the French Financial Markets Authority. So I will start with my presentation. AMF, it stands for Autorité des Marchés Financiers. So in English, it's French Financial Markets Authority. So for the purposes of simplicity, I will use this abbreviation throughout my presentation. AMF was created by the Financial Security Act of 1st August 2003. It represents a merger of three former authorities, namely Conseil des Marchés Financiers, Commission des Opérations de Bourse, and Conseil de Discipline de la Gestion Financière. The objective of this reform was to simplify the regulatory law landscape by providing financial markets players with a single regulatory, supervisory, and enforcement authority. And I will essentially focus today on the Enforcement Committee, which is a part of the Financial Markets Authority. Let's look at the objectives of the Financial Markets Authority very briefly. So according to the Article L621-1 of the Monetary and Financial Code, the Financial Markets Authority is an independent public authority that shall ensure the protection of savings invested in financial instruments and the assets that are offered to the public or admitted to trading on a regulated market, and no other investments offered to the public. It shall also ensure that investors are informed and that the market in financial instruments operate smoothly. In order to sorry, I will just move to, yes. In order to restore the confidence of investors after financial scandals Enron and Vivendi, Financial Security Act of 1st August 2003 has changed profoundly the action regime and created enforcement committee, which is a part of the Financial Markets Authority and whose only function is to rule on the breaches of financial markets law. Enforcement committee can impose two different sanctions, disciplinary and administrative, on three different groups of persons: financial markets professionals, their employees, and any other person that commits the breach of financial markets rules. So let's look at the duality of sanctions. First of all, enforcement committee can impose disciplinary sanctions on those professionals that are supervised by the IMF and on individuals under their authority or acting on their behalf for any breach of their professional obligations. Secondly, administrative sanctions can be imposed on any natural or legal person, regardless of their activity, who has committed or attempted to commit a breach of the financial markets normative rules or any other breach that could possibly undermine investor protection or the smooth operation of the market. These normative rules concern European regulations, European Union law, national laws, and professional rules approved by the Financial Markets Authority. Now, looking at the duality of the sanctions that can be imposed on three different groups of people, we can confirm that the activity of IMF Enforcement Committee has a quasi-judicial nature, meaning that administrative authority can also exercise judiciary function. According to the French Constitutional Council, this is not contrary to the principle of separation of powers, so separation between judiciary and administrative powers. The principle of separation of powers does not oppose the granting of sanction and power to an administrative authority subject to two conditions. First of all, the authority must not be able to impose penalties that involve deprivation of liberty. Secondly, the exercise of the power to sanction must be accompanied by legal measures that safeguard constitutionally guaranteed rights and freedoms. Subsequently, in a further decision of the Constitutional Council that was confirmed and endorsed by the Council of State, there was a principle set forth according to which the accumulation of procedure that could lead to accumulation of administrative and criminal sanctions is allowed and does not fall under the ne bis in idem rule because they are sanctions of a different nature. So we have looked with you briefly at the duality of the sanctions that can be imposed by the IMF Enforcement Committee on three different groups of people. Let's now look with you at the duality of appeal. The decision of the IMF Enforcement Committee can be appealed in two different ways. First of all, they can be appealed to the Council of State with regard to the decision that sanctions the professionals subject to the supervision by the IMF and individuals under their authority or acting on their behalf. Secondly, the decision of the IMF Enforcement Committee can be appealed to the Paris Court of Appeal for appeals lodged by any other person. The decision of the Paris Court of Appeal may be then further appealed to the Court of Cassation or Supreme Court. As you can understand, in the first case, whereby the decision are appealed to the Council of State, there is no possibility to firstly submit an appeal to the Court of Appeal, which is the second part of the French judiciary order. To illustrate the duality of appeal, I'd like to present you a very recent case decision. In its decision of 24 September 2020, IMF Enforcement Committee imposed a fine of 10,000 euro and a reprimand on a fund management company, as well as 100,000 euro fine and a 5-year ban on practicing the profession on the executive of this fund management company. Why? Because there was a failure to comply with the professional obligations. So in total, there were 6 breaches of organizational rules and rules of conduct. While the proceedings were still pending before the IMF Enforcement Committee, the board of the Financial Markets Authority has decided to withdraw the authorization of the fund management company on the grounds that it no longer complied with the conditions required for authorization as a fund management company. The executive of this fund management company filed a petition for interim relief against the decision before the Council of State, which was rejected on the 10th of November 2020. This decision highlights the fact that the IMF Enforcement Committee can impose simultaneously different sanctions: administrative, such as withdrawal of a fund manager's authorization, and financial ones. This duality of sanction and duality of sorry, there is a problem with yes. So this duality of sanctions and duality of appeal presents several difficulties, in my opinion. To begin with, the duality of appeal may lead to the conflicts of case law between the Court de Cassation, Supreme Court, and the Council of State. For example, historically, the Council of State has considered that in the event of a price manipulation by a trader, the bank is presumed to be liable unless it proves that it has implemented necessary measures to prevent the breach of regulatory law rules by its employees. This line of reasoning was upheld in numerous decisions. However, in 2020, in the Morgan Stanley case, the Paris Court of Appeal rejected this argument in the case involving a foreign bank. The duality of appeal also poses several questions as regards the doctrine of the Financial Markets Authority and more generally the doctrine of French financial markets law. We suggest that the harmonization is needed regarding the liability of the financial institutions for the breaches of regulatory law rules committed by their employees, both in terms of substantive and procedural law aspects. This harmonized doctrinal approach shall be binding on all national bodies empowered to impose regulatory law sanctions, which means IMF Enforcement Committee, Paris Court of Appeal, Court of Cassation or Supreme Court, and Council of State, that will then apply all the same approach. In addition, the duality of appeal can also lead to unequal treatment of cases, since for identical facts, a professional and a non-professional will be judged by 2 different courts from 2 different legal orders. Non-professionals will have an advantage over professionals who do not have access to a second level of judiciary order, Court of Appeal. The appeals are made directly to the Council of State, whose decision cannot be appealed any further within the French judiciary system. This difference in the treatment between professional and non-professionals at the stage of appeal against the decision of the IMF Enforcement Committee is particularly prejudicial to the equal treatment of the various parties involved. Further, there is this duality of appeal and duality of sanctions may lead to the divergence in the views between the IMF Enforcement Committee and national courts. The latest case law of the Paris Court of Appeal shows that it's inclined to overturn fully or in part the decision of the IMF Enforcement Committee. The Paris Court of Appeal is also more sensitive to European law and the need to refer the matter to the European Court of Justice. For example, on October 14th, 2020, in the decision that was given by the Commercial Chamber of the Supreme Court, Marie Brizard case, the judgment of the Paris Court of Appeal was overruled and put significant limits on the investigation power of the Financial Markets Authority. However, in the decision of the Supreme Court on 4 November 2020, so less than a month after the first decision, in the AB Science case, the Supreme Court has overruled the judgment of the Paris Court of Appeal and extended the investigative powers of the Financial Markets Authority. So, to conclude, despite the extensive regulation of the Financial Markets Authority and its Enforcement Committee, many questions related to its doctrinal approach remain unanswered. Different decisions of the Enforcement Committee can be appealed in different ways. The different views of the Financial Markets Authority and the courts on the matter of substantive and procedural law do not allow to discern any general approach. All of this issue call for the need to harmonize the approach of the Financial Markets Authority. Now, at this stage of my research, I am more inclined to propose the need to introduce a specialized commercial tribunal that will only deal with financial law matters and not proceed by the harmonization of the activity of the Financial Markets Authority, because it will not allow us to provide an equal treatment to all professionals, employees, and any other legal person involved in a financial law case. So I thank you very much for your attention, and if you have any questions, I will be more than happy to answer them.
Thanks a lot, Maria, for this clear presentation on the diverging problems of diverging possibility of appeal. I can tell you I face as chairman of the Austrian Takeover Commission in Austria precisely the same problem, that some of my decisions go to one institution in appeal and others to another one, and that doesn't make life really easier. I am certain that we will have questions for you at a later stage, but I suggest we now come to our last presentation. Now we look at sustainability disclosure and the role of specialized courts in that disclosure. Well, Alper and Casimiro, whoever of you wants to start, he has the floor, please.
Thank you very much. I will be presenting. So it was nice to hear the perspectives from Spain, Poland, and France. Now we are gonna speak on more pan-European basis. It is very much a work in progress, so any feedback or comment is welcome. As you may notice, there is a slight change in the title, but the content is more or less the same. Let me start with an outline of the project. I will explain each of them in more detail in a minute, but this is an overview of our planned paper, at least. As you may know, sustainability disclosure in the EU is on the rise. Courts have obviously an important role to play in enforcing these disclosure requirements. But our impression or our thought is that courts have generally found it difficult to enforce disclosure requirements, and difficulties will be only confounded in the context of sustainability disclosures. We also think that generalist courts are a part of the problem. Not only historically, they have often fallen short of understanding the complexity of cases, but are now, with this disclosure, sustainability disclosures are now required of uncoding or assessing phenomena that require further knowledge that falls out of their further remit. And in the end, we make a case for a pan-European corporate court as a specialist court to hear cases, among others, related to EU sustainability disclosure regime. So let me talk a little bit about the rise of sustainability disclosure. As you may know, there is a need and demand for sustainability disclosure by issuers and investment intermediaries. With issuers, we mean companies whose securities are admitted to trading on a regulated market. And investment intermediaries are basically investment firms, asset managers, or institutional investors. So proving receptive to this need and demand, a variety of reporting requirements have been adopted or are forthcoming in the European Union. For companies, there has been the Non-Financial Reporting Directive, which is in force, and there is now the successor Corporate Sustainability Reporting Directive, which is now in the proposal phase, but will become law in the coming years. So for issuers, these are the relevant EU legislation. Under this directive, the information required to be disclosed pertains to both the effect of climate change on the company, so the climate risks for the companies, and also the impact of the company on the environment. So this is called the double materiality requirement. For investment intermediaries, there is also a complex legislation for disclosure, which is the Sustainable Finance Disclosure Regulation, which is already in force. It requires the disclosure to the ultimate beneficiaries, to ultimate investors, of information on the sustainability risks and the principal adverse impacts on the sustainability factors during the investment decision and processes. This is not the end of the story. There is also now the taxonomy regulation, which is already in force and will be further developed by the Commission in delegated acts. It extends disclosure requirements for both issuers and investment intermediaries. For example, for companies, they are required to disclose how and to what extent their activities are associated with economic activities that qualify as environmentally sustainable under the taxonomy regulation. So that was the rise of sustainability disclosure requirements. Now we look at the challenging role of courts. As you know already from your practice or from your academic work, enforcement is the key to ensuring actual and effective information flows within the market. It is not enough to pass legislation requiring some disclosure. The law and finance literature clearly shows that courts are a major part of the enforcement, and also they are poised to play a crucial role in supporting the implementation of policymakers' sustainability-related agenda in the EU. And with this increasing range of sustainability disclosures, cases before courts regarding misleading or inefficient disclosure are likely to grow. So the main question for us is whether the courts will be up to the task of protecting investors and satisfying the need for climate-related information, while conforming the legitimate cases of non-disclosure for issuers and investment intermediaries. So we have a look at the past, and from that look, we have a prediction for the future. As you may know, the difficulties that are associated with the enforcement of disclosure requirements are set in history. In our opinion, European courts have traditionally found it difficult, to say the least, to enforce disclosure requirements effectively, whether laid out in the prospectus or market abuse regime, or contemplated under the regime for the marketing of financial products for investment intermediaries. For example, courts might have taken too lax or too narrow an approach to materiality. And we predict that enforcing sustainability disclosure requirements will be more challenging for the courts. these are the challenges we identify regarding enforcing sustainability disclosure requirements. First, courts, as always, have to navigate the intricacies of technical and complex legal texts. They need to engage in the process of turning vague regulatory provisions into bright line ad hoc rules. As you know, the disclosure requirements have been always a little bit general. They are not really specific. This is the case also for sustainability disclosure requirements. So courts need to really turn these provisions into bright line rules. And also, this is a new challenge, I guess, or an extended challenge. They need to shed light on their constantly changing content by drawing upon the most recent scientific findings regarding climate change. So we like to illustrate the challenge with an example. For example, under this sustainability directives, issuers, companies are required to disclose, among others, physical risks posed by climate change to their operations and assets. And consider, for example, a case where investors demand damages because a material physical risk which had not been disclosed before materialized and caused a drop in the share price. In this case, judges need to analyze whether the physical risk at that time should have been foreseen by the company and therefore disclosed. This in turn requires an understanding and analysis on the part of judges of spatial and temporal climate data, which indicate any physical risk for the company at that time. Granted, there will be simple cases which can be easily remediated by the court. Companies may ignore to disclose basic information that is required, but in most cases, the disclosure, misleading disclosure or insufficient disclosure, it will be complex, more complex. So at the roots of the problem, we asked some questions and tried to provide some preliminary answers. We think that ineffective enforcement of disclosure requirements can be a function of a fundamental problem of institutional design. Enforcement powers have generally rested with generalist courts that have consisted of unspecialized judges who found it hard to appreciate the intricacies of disclosure regime. And obviously, analogous problems will likely emerge when it comes to the enforcement of the more complex sustainability-related disclosure requirements we just sketched above. So acknowledging the existence of this problem in turn calls for an inquiry into what the optimal institutional design ultimately should look like. And our proposal is to create a pan-European corporate court as a specialist court that would, among others, deal with sustainability disclosure cases. We say it would deal with sustainability disclosure cases. Obviously, this would not be the only power of the court. There can be some other powers that or some jurisdiction that can be allocated to this European pan-European corporate court, but we concentrate right now on the EU sustainability disclosure regime. This is similar to a proposal by two US prominent scholars, Gilson and Schwartzman. They also argue for creating a European level corporate court. In that case, they focus on regulating private benefits consumption by corporate insiders. This proposal is also complementary to Wales' proposal. As you know, the EU securities regulation is pretty much harmonized, but it is only for substantive rules. The liability regime is a little bit harmonized, but still member states have their own regimes for the liability, private liability. Wales argues for the harmonization of private liability for failures to disclose information under the EU securities regulation. So our proposal would complement, I think, this harmonization of private liability. But it is important to note that by a specialized court, we imply specialized judges. and accompanying facilitative institutional arrangements. Formalistically branding a generalist court as a specialist will not bring about the intended results. I think my Italian colleague can explain better, but this was more or less the case in Italy. Just taking a generalist court and saying them, okay, you are now a specialist court, it will not bring the intended results. So why do we need specialization? First of all, the intricacies of the law indicate alone the need for specialization. There is a large array of new concepts and terms for judges to get familiar with. For example, climate-related risks, transition and physical risk, environmental impact, sustainability risk, sustainability factors. These are the terms that are just vigilance from these directives. So judges need to understand these concepts and distinguishing them, and more importantly, the rationale behind the disclosure requirements, because it varies between these. The rationale varies between the rationale behind the disclosure requirements varies. Sorry, and the intended audience also varies. Some are for investors, some are for audience broader than investors. There's also relevant evidence. Two US scholars, again, they look at some complex bankruptcy-related issues and how generalist courts in the US decide on them. And they find that these generalist courts generally err in deciding the complex issues. There is also the other side of this sustainability disclosure requirements. In deciding whether there was an omission or misrepresentation of information, judges will need to follow the external trends, analysis, and draw on the climate science necessarily, which we think is a colossal effort for a generalist judge to deal with. So what are the benefits of a pan-European specialist court? It will bring significant expertise that will bear on important cases that will also shape market expectations, and it will help also realize the sustainability agenda the policymakers are pushing right now in the EU. A single court will achieve high specialization, and there will be economies of scale. The effort per case will be lower than in a case where there are some specialist courts scattered across the EU. And also these two combined would help achieve speed in closing the pending cases, because the speed is one factor that investors are really caring about. So this specialist court would also achieve speed, and it would also prevent regulatory arbitrage. Different interpretations of and judgments on disclosure requirements in national member states courts will ultimately lead to an unharmonized application of EU law, and will enable market players to benefit from regulatory arbitrage. For example, if you're a company, you can move to another member state where courts are laxer in their application of sustainability disclosures. And it is also in line with the creation of a European single access point for financial and non-financial information disclosed by companies. This is envisaged under the European Capital Markets Union Action Plan. So there will be a European single access point where all the information about companies will be available. So this why not also accompany this single point by a single point court? So let's look at a little bit the design features of a pan-European corporate court. Obviously, there is the issue of how judges gain the necessary expertise in complex legal matters, but we focus on the fact aspect because most sustainability disclosure cases will be fact intensive. So there's the question of how judges gain the necessary expertise in determining the facts as well. And we identify generally two models. We do not prefer one of these models, but we think one of these models can find a lower or higher acceptance among member states. The first model is is when only those with a law degree can serve as judges. This is like the Delaware Court of Chancery, which is one of the most successful examples of a specialized court. If this is the case, then we say the court should be well staffed and resourced, including non-legal experts like climate experts. If not, then the building necessary expertise and knowledge for the specialist judges will take more time, which would decrease the efficiency of litigation and ultimately negate the use of courts as a private enforcement mechanism for the investors. The second model is when non-lawyers can also serve as judges, and this is the case of Netherlands Specialist Corporate Court, which is another successful example. So in this model, we think relevant experts should be appointed as judges on the sustainability disclosure cases. Again, in the example of the Netherlands Specialist Court, non-legal experts such as accountants and auditors get appointed rotatingly on cases where their expertise is relevant. A similar model can be developed in our context. For example, climate experts can sit as judges when necessary to help other judges rule on the necessary elements of the case. Certain procedure rules can be also necessary for this specialist court to function, such as extensive discovery and pleading rules that help uncover as much information as necessary. We know that this is not really the case in some member states, but the advantage of adopting a pan-European corporate court is that it can have its own procedural rules. And another point is that location should be carefully chosen because it may be an important factor in cultivating the reputation of the court and contributing to its success ultimately. In the end, we also acknowledge some problems with specialized courts. Some say judges become too powerful. I think this is a necessary trade-off we need to make to achieve expertise. Another complaint is expert judges are not independent. This is really the case in Netherlands. These auditors or accountants are generally from the Big Four, which cast a shadow on their independence as judges. We acknowledge that this is a problem, but in the first model, when you have in-house experts that are connected to the court, then you can solve this problem as well. Another problem is that there is no review of facts with specialized courts generally because they are specialized because they only review the facts and some legal questions go to the appeal. Again, this is, we think, a necessary trade-off in return for expertise. I hope I have been clear in sketching our design or our proposal. As I said, this is pretty much a work in progress, so we appreciate any comment or feedback. Thank you very much.
Thank you, Alperen. Thanks, Casimiro, for the presentation of that interesting topic, and I'm sure you will get comments on that one. Now we have ample time for our discussions, 3/4 of an hour, if I speak correctly. So I would once again ask you to write questions, those in the audience, to write questions in the channel you are using. We will collect these questions and then I will ask them to the presentators. Let me just start briefly by asking Barbara, you've presented that there's quite a considerable number of cases on investor protection. Are they taken in the Supreme Court by a specialized chamber, una sala, or is this just general? Is this the general Supreme? Is this just general competence of all judges? And anyway, would you advocate more specialization, or do you think that the current Spanish system adequately deals with these issues of investor protection cases?
Thank you, Professor Wiener, for the question. In Spain, the Supreme Court has 4 salas. Civil is for civil, and for commercial. For two, the jurisdiction, the material jurisdiction is mercantile, business law, commercial law, and civil law, to both. But only on the top, at the Supreme Court. In first instance, yes, there is specialization, juzgados de lo mercantil, but only on the first step, first instance. And when you go to the Supreme Court, there is one sala de lo, it's called Sala de lo Civil, it's the name, Sala de lo Civil, and there are no judges specialization. But I have to say, I know almost all of the judges, and I have to say they are really well prepared in order to fail, in order to know, in order to apply this legislation. And the proof, in my opinion, the proof is Supreme Court. It's going stating case law in this matter. In my opinion, they are really good at this. They wouldn't need more specialization. In my opinion, humility. In my opinion, in Spain.
Thank you very much, Barbara.
Sorry, at Supreme Court.
I understand. Okay. If no one wants to jump in on that one, Casimiro, yes, please. Do go ahead.
My question was more about how the enforcement style in Spain is, whether they take into account the real substance of the facts or whether they just approach the litigated matter in a more formalistic way. I mean, there is a huge divide between in few countries you can actually observe that sort of enforcement that you see in the US. And my suspect is that Spain is not really an exception to a more general European trend. So you would see a more formalist approach. But I just would like to have a confirmation because, of course, this is also important for our paper. So.
Yes. Casimiro, of course, is a formalistic approach, of course.
Thanks.
But this is not a bad approach, in my opinion. It's quite, in my opinion, it's quite safe.
Well,
I don't know.
Yes. Well, depends.
I don't know if I understand. I am explaining correctly. I think formalistic avoids risky decisions, in my opinion.
Yes, but I guess Professor Wiener can definitely say much more about that, and I can only add what I've learned in my own experience as a lawyer first, and as a potential academic later on. When it comes to takeover law enforcement, if you are too formalistic, basically you just kill investor protection in the creep, because you will actually see many transactions which are designed exactly to circumvent the rules which are supposed to protect investors. And that basically means that formalism is not really the best way to go. Of course, I understand that from a civil law perspective, we are much more used to get the sure thing. So let's apply the law the way it is without wondering whether we actually achieve anything in terms of real investor protection. But I would think twice before agreeing on the fact that formalism is the best way to go. But I understand the way you see it, and I would like to know more. So I would definitely keep note of your paper once it's ready, and think
Me too.
To get.
I will think it twice too.
Yeah, well, I can tell you. I can tell you that when it comes to takeover law, which to some extent really overlaps in terms of, at least when it comes to enforcement of takeover law, it really gives a number of lessons which might help your discussion, because advocating formalism in this context might really backfire. That's my impression. But Professor Wiener was saying something, so I guess.
Yes, I just want to say that, of course, formalistic decisions from the point of view of the judge are safe decisions. And that was probably the point Barbara was making. And hence, formalism, and that was said already in the morning, and there's a lot of truth in it, formalism tends to decline as experience increases. Because the more experienced you are, the more comfortable you feel in an area of law, and the more ready you are to take difficult substantive decisions, and the less you want to rely on formalism, which very often is the cheap way out. So I think, and that was said in the morning, and I think that is basically correct. And that, of course, is an argument which brings us to the court organization, to the organization of the court system. If, and of course that is a big if it is successful, the attempt to get specialized judges into a specialized court, this is not a given, you must achieve that, then there is a certain chance that you will get more substantive decision, which brings us anyway to the questions already as far as, no, I've got one from Paula Del Val, who was presenting in the morning, and she says, I would say the general critic as regards the lack of familiarity with the business background or the context in which decision-making takes place is true for Spain. So that is a more critical approach, so to say. But I think you will always, in any legal system, you will encounter judges of all types. It is impossible just to get the best qualified. Anyway, I have a question for Piotr from Andrea Zorzi. Hello to everyone.
Can I say something, Martin, for like a judge for the Barbara? I agree that the formalists kill sometimes protection, but I think that is working in the other way. The formalists also may kill the judge in the make the decision. So please try to look at this problem in the other view. One of the protection, okay, but the formal is also the problem for the process in the mind of the judge. I as a judge also very often have to choice protection or the human rights, and for the other way, formalism. And sometimes it's very difficult to find the third way. So I think that we have to remember that the formalism make and prepare the way two ways for the protection, and also for the judge who in this area of the formalism make decision for the protection.
Okay, can I just add, Piotr, to you, the question by Andrea Zorzi. He says, perhaps I missed it at the beginning, but what claims would be adjudicated by the Capital Market Court? I understand no consumer claims, no crimes, but apart from that, only cases pertaining to listed companies, question mark. And may I just jump on the question and ask, why would you exclude all consumer claims, especially those referring to damages suffered by consumer on the capital market? Why would you think this is not appropriate for the capital market courts?
Thank you. It's a very important question, and I think about many times about this problem. We have to back to my first direction, that the background of the prepare and the start capital market court in Poland. At the beginning, I think that we very narrow try to case in this court. So after a few years, when the court will be stronger, I think that will be closer to the consumer, and we try to wider cases, try to the wider case get to the court. So at the beginning only, I think that will be court not for the consumer. And after a few years, when the court start bigger and stronger, we will think about the cases of the consumer. I'm afraid that at the beginning, when we start very wide, for example, corporation, consumer, and the penalty, for example, for crime on the financial market, this court will be at the beginning very slow, and I think that it will not successful. So I think that will be a few level for the starting and for the growing this court. And after a few years, the next level will be wider than the beginning. I think that will be good start for the narrow case. And after a few years, when this project will be, I hope, work good, we will try to get the new cases also with the consumers, and also with the, for example, maybe criminal aspect of the financial market. Mm-hmm. I'm afraid about the organization field, that will be not good background for the starting court.
Okay. Let me just add up. It is actually a question to three of you, namely to Piotr, to Alperen, and to Casimiro. All of you said that you would not just need the institution, you would not just need the court, but you would also need some special procedure, some procedural law which overcomes weaknesses perceived under Polish law, or in your case, Alperen and Casimiro, under the legal systems in general. Isn't it dangerous to turn too many screws at the same time, so to say, and try to achieve everything at once? Do you really think that you can do this all say, design it on the desk, on the table, or wouldn't you need more experience, or is it already clear where precisely the problems are so that you can do both at once? So whoever wants to start of the three of you.
Well, I can say something. I mean, I cannot say that we need extra specialized procedure, so to speak, for 100%. Obviously, it needs to be thoroughly taught. But in Europe, for example, in the Parmalat scandal in Italy, the litigation took place in the US rather than in Italy, because the US procedural laws were more favorable to investors because of this extensive discovery rules and pleading rules. I mean, by necessity, you have some. I mean, the issuers are here on the dominant position, so to speak, against investors, because they have all the material at their disposal, which would help investors to prove their case. So if you do not help investors to recover these materials, then there will be necessarily a gap in terms of investor protection. But I do not say that these rules are without any disadvantage. Obviously, you need to make tough decisions, or there are certainly trade-offs. But I think in the least that investors are disadvantaged if procedure rules do not help them. I mean, I can't say only that, but obviously I agree with you also.
One thing. Okay, thanks. So, well, of course, at the theoretical level, there's it's not that easy to think about so many changes at once. So it's easy to think that we can do that when we sit at a table, but at the same time, of course, it would be much harder, much more complicated to implement them when it comes to turn them into practice. At the same time, one thing which cannot be denied is that unlike general litigation, corporate litigation and investor issues related litigation always builds on a huge information asymmetry between those who invest and those who actually take the money, so capital providers and capital seekers. And to the extent that this information asymmetry exists, general rules, general procedural rules actually struggle at achieving their goal. And the reason is obvious. They really, as Alfred already pointed out, they don't allow investor protection to engage. They don't allow investors to engage in that sort of discovery, which is crucial in order to achieve the goal of finding out what actually happened. So, from this perspective, to think about special rules, particularly when it comes to the allocation of burden of proofs among litigants, well, that's something which we could not really do without. But I'm not sure how much we should stress this into the paper, but perhaps it's something which we should somehow just hint at it without getting too much into the discussion. But thanks for the suggestion.
Piotr, you want anything to add, or you're fine?
No, thank you.
Excellent. So this brings me to a point. These different, Maria, these different lines or routes of appeal. I do have that in the Austrian takeover law, because I have generally an appeal to the Supreme Court in most cases, but in administrative sanctions and fines, the appeals go to the administrative courts. And this is structurally very similar to the situation you are facing. It's even worse because it's the case against the same person with appeals in two directions. So, but what I was wondering is, these things do not happen by design. You don't design things that way. Why? How did it happen? What was the development that brought the situation we have today? Why is it that way? I think you could help us with that in order to understand it better.
Yes, of course. If you come back to the duality of appeal, I explained to you previously that there are two possibilities to make an appeal against the decision of the IMF Enforcement Committee. So first of all, you can make an appeal to the Council of State, which is the highest administrative court, the High Administrative Court in France, for the decisions that concern the professionals supervised by the Financial Markets Authority, or the individuals acting on their behalf, so for example, the employees. And second, the possibility to make an appeal is to the Paris Court of Appeal for the appeals that are lodged by any other person. In this situation, I think the main explanation for this is that you have to make difference between the nature of the person that presents a claim. So if it's a person that is a nature or legal person that is in no way concerned by the breach of financial regulation by the entity supervised by Financial Markets Authority, it can make directly an appeal to the Paris Court of Appeal. Whereas when the case concerns the regulated financial institutions, the appeal has to be made directly to the administrative court. So I agree with you that this is an approach that is not very consistent, and that's why it needs to be harmonized. Yeah, so this is my explanation about this.
Thank you. Now, I do have another question from Paula for Alfred and Casimiro. And one thing which is I was wondering about as well, so I love to read that one. If I understood correctly, Pavlos says you're considering private enforcement. In many jurisdictions, such claims would be rare. Are you also looking at public enforcement, or would public enforcement of the NFRD somehow eventually benefit from an improved court review system? Why do you focus so much on private enforcement, and why do you not say let's just get an authority which does that?
So, Alperen, you want to go?
Well, one reason is very pragmatic, because this conference is about courts, not the public enforcement. So that's one reason. But there is nothing to rule out public enforcement as well. And we do not say private enforcement is better than public enforcement or vice versa. But when you look at this law and finance literature, this LLSV, if I remember correctly, they argue that what matters is really courts, in the European Union, at least, private enforcement is weak, not because investors do not prefer private enforcement, because it generally takes time, and I think generalist courts maybe are not up to the task, or I mean, there are some procedural hurdles, etc. So I think courts, if investors are given a capable body that would handle matters really speedily and with expertise, I think there is no reason why private enforcement would also take off in Europe. But we do not suggest or that private enforcement should be preferred to public enforcement or vice versa.
So I wanted to add something which, of course, builds on what Alperen already explained. The thing is just that, at least when it comes to Italy, and particularly when it comes to takeover law enforcement, it's not so clear. Of course, conceptually, the divide between public enforcement and private enforcement, it's clear, but at the same time, decision taken by public authorities such as Consob, which is the Italian financial regulator, can be litigated in the courts. And although anecdotal evidence suggests that courts struggle at understanding the litigated matter, so courts don't really understand what the problem that the investors are discussing against Consob are, or well, what the sophisticated investors that appeal the decision by Consob are. So from this perspective, I think that having a specialized court which actually can deal with the problems that are being discussed before Consob and with the decision taken by Consob when it comes to the enforcement of some specific parts of of specific regulations can also help. It's not that we necessarily have to think about private enforcement, but of course, it should be clear that our focus is on actions brought by investors privately. So, thanks.
Thank you. Paula says, "Good point." So you've convinced someone. But this is also a question I'd like to address to Piotr similarly, because if I understood you correctly, you said you advocated a mixed system of common or civil courts on the one hand and administrative courts on the other. Am I correct if I say you meant that such a capital markets court should have both the power to hear complaints by private individuals against other privates and to hear complaints by individuals against the market authority? So both types of cases could be covered?
Yes, I think that will be a good direction about the right procedure before the capital court. I think that will be, for the beginning, the Poland will start with the public cases will be, of course, more administrative procedure. And the next time and the next level will be procedure going to the direction of the commercial or civil procedure. But I think we will be two parties of the codex of this procedure. One for the corporate, for the FSA, and the other for the consumer on the private case. I think it will be two other. I think it's difficult to start to take in the one part the public and the private aspect of the procedure. I think it's difficult.
Mm-hmm. Thank you. Thank you.
And can I have a question to the Maria?
Yes.
Please.
Maria, thank you for the very interesting speech. As you saw and listened, in Poland we prepare for the capital market court. So I would like to know how long does the process take in France? You spoke about the sanction. So how long in the France? How long does the process take in France? And for example, in the France, could you security a case of the sanction? How it's working in France?
Yes, I actually wanted to talk about that, but then I decreased my presentation due to the time limit. So, for example, in 2020, IMF Enforcement Committee has issued 25 decisions, which represent a slight decrease as compared to the previous years. And this is mainly due to the postponed sessions of the Enforcement Committee because of the COVID-19 pandemic, but it takes the average time is between 1 and 2 years for the Enforcement Committee to take a decision in the case. But of course, this we do not consider then the further appeal that may be made by a person, for example, to the Council of State or to the Court of Appeal.
It's quick, so, yes, to 1 year. So
this is a timeline.
And for example, on the security, is there an opportunity to security, for example, the sanction between the last decision for the authorities or the court?
Can you repeat, please, your question?
Is the possibility to security the claim of the before the court make the decision between the start and the end? There is possibility to security the claim.
I mean,
by a preliminary injunction or something similar, no?
Okay.
Yes. So while, for example, while the decision is pending at the IMF Enforcement Committee, of course, the interested party can apply for interim relief, but it is not sure whether it will be given or no. Yes.
And for example, Barbara, how long in Spain this process about the court?
Which court? First instance.
And all. How long it take?
Many years. I couldn't say a range, but many years. Too much.
Sorry, Piotr, I just wanted to clarify when you ask me what is the duration of the procedure. So here I'm talking about the procedure of IMF Enforcement Committee. Of course, I'm not speaking about procedure. Yes. So of course, in the court, the procedure takes much longer than the Enforcement Committee.
I suppose. I know. Thank you very much.
Okay. All right, so I see nothing in the chat. Maria, did you want to ask a question or?
Yes, I'd like to ask a question to Alperen. So I really enjoyed your presentation, and I wanted to ask you about this specialized court at the level of European Union. So how do you actually see its creation? Would it be something like a European Court of Human Rights? So firstly, the person will need to go through all the judicial procedure in its own country and then appeal to European Court, or how would you propose to do that?
Yeah, thank you for the question. I mean, we must admit that we didn't really think through all the intricacies or all the parts of our proposal, but I would say we didn't imagine something like European Court of Human Rights, where you first go to your national court, then to the European Court, because it basically defeats the purpose, because it takes a long time. So our purpose is to achieve speedy decision, and then in this instance, you would go directly to this specialized court, and I mean. And I think there will be no review of facts in the end. I don't know whether that would be a first instance court, or there would be another appeal court. We didn't think about that, but I think that's a court where investors go directly in the EU when there's a claim arising from an EU law instrument like the directives we just talked about. I hope this clears out.
If I can follow up on that one, very interesting. I mean, there's huge problems, of course, of European constitutional law on that one. We've seen that in the patent court, where we needed a separate international treaty in order to get that going. I know that this is not the focus of your research. I'm perfectly aware of that. But one question we do have. You enumerated a number of legal instruments of the European Union which such a court should enforce. And the two main instruments which you started were directives. That is, legal instruments which have to be transposed by the member states, and which will be transposed differently in different member states, as experience shows at the end of the day. How does this fit, this decentralized legislation? How does it fit, and how does it fit with centralized enforcement?
Yes, I mean, that's a problem that we are aware, but when you really look at the substantive provisions of these directives, even though they are directives, they do not really give that much of discretion to member states in harmonization. Obviously, these directives need to be transposed into national law, and there can be obviously differences, even though there's not much room for difference, I think. When that is the case, then the court would take into account the national implementation of the directive that the relevant issuer or relevant investment intermediary is subject to, but we don't think that's something that's a big hurdle before the harmonization or specialization of the court, because we think the differences would not be that big, at least in the substantive area.
So this court, sorry, if I may follow up directly on that one. So this court would not be responsible for the tort claim as such, because the tort claim is subject to national law, very different in different countries, but only within a tort claim brought before a national court, only for the preliminary issue of whether the information requirements have been fulfilled.
Yes, that's true. But I mean, you can think of different models. And as I said, we didn't really think through all the possibilities, all the issues that would arise. That's pretty much working in progress. And you are already illuminating the potential issues that we need to address. But that's one model. And another thing that, I mean, there are a lot of scholars already arguing for the harmonization of the private liability regime under the EU securities litigation. I mean, there is also some harmonization, but I think in most cases, it is up to member states' law. I mean, if you manage to harmonize the private liability regime, which is a big step, I think, to admit, then you can also envisage a court where you integrate all the claims together. But if it is not the case, then this court would work like the European Court of Justice with this preliminary inquiry thing, I would say.
Mm-hmm. And the issue, and this goes, by the way, to Alper and Casimir and Piotr, the issue of regulatory capture, that is the capture, it is easier to capture specialized institutions by interest groups, which may be the issuers in a capital market court, which may be NGOs in a court specialized on in the disclosure of environmental risks. How would you deal with that one? And this goes also, of course, to the other participants. If you want to say something on the danger of regulatory capture in the AMF or in the judicial system, what would your take be on that?
Should I start again? I mean, the regulatory capture is an issue. I think that's an issue we just acknowledge in the sense that judges become too powerful. I mean, they can also be captured by specialized interests if they are the go-to person on a case. But I mean, there's also the other side of this story, because when you look at the Delaware Court of Chancery, the judges, they do not start, mostly judges, they start as practitioners, and after a while they switch to become judge. And this interaction between practice and the bar and the judges actually increases the reputation of the court, because they trust these judges and they know that they know what they're talking about, what they are deciding on. So, I mean, there is an issue of regulatory capture perhaps, but on the other side, maybe if there's close relationship with this plaintiffs, defendants, or the court, then it also contributes in a sense to the reputation of the court and contributes also its success, I would say. But obviously that's a trade-off. I mean, I cannot rule out that there will not be a regulatory capture. I mean, if it is the case, then bad luck, I would say.
Thank you. All right, so I think we are running.
Can I also have a question to the Arthur and Casimiro?
Yes, please, do go ahead.
Thank you for the presentation. I have two questions about the conclusion. Now in Poland we have problem relationship between the European Court and the Polish Court. So my question is, what will be the relation between the national and the European courts? And the second question is, I think that it's a good idea to the European Court. So it will be something like similar to the court in terms of intellectual property, or something like that. Like I try to find the answer on the question. What kind of the court will be the level European?
Sorry, I didn't get the second part of your question.
This proposition of the European Court will be similar for the court on terms of intellectual property, something like that?
Yes, I mean, it would be, I guess, similar. As I said, there are things need to be developed, but the relationship between national courts and European courts, I guess, would be complementary. I mean, European Court would be obviously the court to the go for the investors to decide on this misleading or insufficient disclosure. But then there needs to be also some damage to decide, which, as Professor Wiener pointed out, needs to be dealt with national court. But it may also be problematic from our side that investors need to go to two courts, which which is problematic for them. But in Netherlands, actually, that's how it works. In Netherlands, they have a specialized corporate court which decides on these fact-intensive issues. And if according to that decision, the investors go to another court for damages, and apparently it didn't really prevent this Netherlands specialized court from being successful. So it is not a big issue if the European court and national courts are complementary rather than substitutes.
Thank you.
All right. Well, I can just say thank you very much for these excellent presentations, for the, I think, fruitful discussion we had afterwards. It was really a pleasure being with you here today and listening to you and talking to you. And I suggest that we'll finish now, and I think we reconvene here at 4:30 for our last panel for today. Thanks again, all of you. Thanks of those of you who've been listening in. And well, let's see each other again at 4:30. Thanks a lot and bye.
Thanks, everybody.
Thank you very much.
Good afternoon, everyone. Welcome to our third and last panel for the first day of our conference. Under normal circumstances, this would be the one just before the nicest part of every conference, meaning going for a dinner. But since due to the lockdown in Austria, it is not just all the restaurants are closed, but also travel. There are some limitations on travel, and therefore our experts were not able to travel to Vienna. So we need to stick to this online platform. To all of you, to those of you who switched on now, just to remind you that this conference, due to this unusual circumstances, we are organizing this as a two-day event. But unlike the regular schedule when the two-day conferences are on the 2 consecutive days, this two-day conference will be held on 2 consecutive Fridays. So we are meeting today on this Friday for the online session, or 3 sessions actually, and then next Friday, exactly 1 week from now, we hope and very much look forward to meeting physically on site here in Vienna at the premises of Polish Academy of Sciences. And if the COVID situation does not deteriorate during this 1 week, we hope to be able to hold the meeting physically on site. Having said this, please let me welcome our speakers. I will have the privilege of chairing this session. So please let me start with brief introduction of our panelists today for this session, and then I will hand over to our speaker. So this session happens to be Italian-Polish meeting, but I'm certain we will have many comparative observations as well. So we will not just remain in this Polish-Italian company. We have 4 speakers, but we will have 3 presentations. One of them will be delivered jointly by Valentina Allotti and Federico Raffaele, my good Italian friends. Just to mention that a few years ago, I think now it is 3 years ago, there was a nice conference hosted by Luis Guido Carli University in Rome, which is also a member of CECL network, that is the umbrella organization, and under the aegis of CECL, this conference is also held. So we still remember this very nice conference in Rome. We are now in Vienna. So to introduce our first speakers, Valentina is a senior legal policy officer at Asonime, which is the Italian Association of Joint Stock Companies. She works in a unit that is responsible for capital market and listed companies. She's specialized in company law, securities market regulation, and dispute resolution, with a particular focus on the European law. She is the contact point and the voice that speaks on behalf of the association in all the issues, policy issues. She is responsible for drawing up position papers, policy briefs, and other responses to whatever consultation processes that are launched by the European Commission. And as we know, this is the way the European law is produced. She is also vice president of the Italian Association for Arbitration, where she coordinates the focus group on corporate arbitration. She is also a member of ICC International Committee on Arbitration. Furthermore, she is a member of the Policy Committee of European Issuers, where she chairs the working group on company law. And also she is a member of Smaller Issuer Committee there. She is also a member of CEG Corporate Events Group at the AMI SCO. And when it comes to academia, she holds a PhD in comparative law. And as I mentioned a few years back, she was involved also in organizing one of the conference in the series. Federico Raffaele, I'm honored to call myself a long year now friend of Federico. Every July, he is the host of a very renowned summer school that is held at Luis Guido Carli University in Rome on company law and capital market. Federico is adjunct professor at the very university, Luis Guido Carli. He is also vice president of the Harvard Law School Association of Europe, and he is now in-house lawyer, head of legal finance and M&A at Team Società per Azioni, which is the Telecom Italia, as I understand, the biggest telecom company in Italy. Before, she has a long year experience as a lawyer, also working for numerous law firms. She graduated both from law and economics, which is a very useful combination. She holds an LLM from Harvard Law School, where she was active during his time serving, among others, as research assistant to Professor, very famous Professor Mark Rowe, and also as editor for the Harvard Business Law Review. His PhD is from Louis Guido Carli University, when she also was a postdoc fellow specializing in corporate law. Now, turning to our speakers from Poland, connecting from Kraków, my colleague, Dr. Maciej Durbas, who is a practicing attorney of counsel at a law firm that I also have the honor to work with, Kubas-Kozgałkowski, based in Kraków, also with office in Warsaw. Maciej is an expert in the field of dispute resolution, has significant experience in arbitration, serving as counsel, but also arbitrator or also secretary of the arbitrary tribunal. His field of expertise covers many fields. Company law, obviously, is among those. He is also a member of the Chartered Institute of Arbitrators, and what I highly appreciate, Maciej, for a long time and successfully has coached students of the Jagiellonian University in Kraków who take part successfully, as mentioned, in moot courts. Maciej, I'm very glad that you accepted our invitation. And another long-year friend of us, Dr. Krzysztof Grabowski, who is a legendary figure at the Polish capital market, one of the first people who was given the license of the broker. So he is established expert on the capital market, that he witnessed the development of the Polish capital market from its very beginning in the early 90s. He is also affiliated with Other Hand Institute, where we work together on many conferences in Poland and abroad. He is also very active in the European level. It could take me too long time to mention all his affiliations and works, but at least one thing I want to emphasize: he's a member and expert of the group on technical aspects of corporate governance that works under the mandate of the European Commission. So he has a direct influence on the European lawmaking directly at the level of the European Commission as an expert advising to the European Commission. But the capacity in which I think most of the knowledge that Krzysztof will be sharing with us, he is one of the key figures on the expert witness market in Poland, with a very rich experience of delivering expert opinions to the courts on various aspects of financial instruments and other very technical issues. And I think he is the best example to share with us his experience of how blurred might be the line between what pertains to the law and what is this very special expert knowledge, as those two tend to overlap. But if it would not be enough to praise Krzysztof, he is unique in any company in this group. If at any conference that brings together lawyers and economists, Krzysztof graduated in chemistry. So a very unusual background for an expert in financial regulations, but after a couple of decades of hands-on experience with the Polish capital market, this is just an anecdote. For the most of his professional life, he has been working on the capital market and looked at this from very, very different angles. So I'm very glad, Krzysztof, you also accepted our invitation. And well, having introduced our experts, please let me now give the floor to our Italian friends who will now speak on arbitration, but not just on arbitration, because this conference is not purely devoted to arbitration. There have been many conferences on arbitrating corporate disputes, but since specialized courts face a very natural competition in arbitrators, we look what lessons can be learned and how this competition can look like in the future. Valentina, Federico, floor is yours. Floor is yours, please.
Thank you, Arek, and thank you for inviting us, and thank you, thanks to the organization for having us, although not in person, which is such a pity. But anyway, we're trying to enjoy the conference. We have already enjoyed the conference this morning, and we're trying to enjoy the rest of it. Yeah, I mean, what you just said is what we felt when we first thought of how to take part into this conference. We thought that the game might be which one doesn't belong, right? So we would have raised our hand because we would be speaking about arbitration in a conference devoted to the topic of specialized courts. That might not be the right arena where to speak about arbitration. But as you said, I mean, what we are actually focusing on is a purely Italian perspective, from which we are going to derive, we'll make a case for a European approach. So we're trying to, let's say, to sketch out some of the concern we have with Italian regulation, and we're trying to see our proposal for a modal ICD arbitration, whereby ICD, I mean intra-corporate disputes, in the eye of a pan-European approach. Also, I mean, from which also practitioners and people looking at the topic of specialized courts must take a look at. To some extent, we are very close, but opposite to what Casimiro and the other colleague from Germany said in the last panel. But we are looking at it from the eyes of the arbitrators. And in addition, we also saw that Professor Zorzi is going to join the conference later on next Friday, and we wanted to avoid any overlap. And eventually, and to conclude my very initial thought, we do not underestimate the importance of specialized courts. We're just making a case that arbitration might play a role, let's say a complementary role, supplementary role with respect to courts. The presentation will follow, will develop as follows. So I will leave the floor to Valentina for presenting the case, and then we will just Valentina and I will just come back and forth presenting specific aspects of our presentation. The idea is to have the presentation a bit more dynamic than if one only speaker had spoken. So I'll leave the floor to Valentina.
Thank you, Federico. Thank you all for this invitation. We are very glad to present research and to debate this with you. We will start from a very briefly description of the Italian legal framework. In 2003, Italy enacted a comprehensive and balanced regime for intra-corporate dispute. And in doing so, it expressly allowed for an arbitration clause to be inserted in the bylaws and addressed and solved many of the issues that normally corporate arbitration face, such as what are the quorum to adopt an arbitration clause in the bylaws, how to define subject matter arbitrability, how to ensure that the appointment of arbitral tribunal is made in a typical multi-party dispute. The important thing to note is that this regime on intra-corporate arbitration was introduced in the general framework of the reform on company law, with the specific goal to enhance the enforcement of shareholder rights, to promote private autonomy in shaping internal governance arrangements of the company, included arrangement on dispute resolution, and to render the Italian system more competitive. However, there is also an explicit ban on the use of intra-corporate arbitration for listed companies. This seems quite contradictory for us, because we argue that ICD arbitration is especially useful for listed companies, since it can provide redress to shareholders and improve management accountability, enhancing the effectiveness of private enforcement of shareholder rights, and can trigger positive externalities in attracting foreign investment and promoting capital markets. Also, there was no clear reason why this ban was introduced, because no explanation was given in the report which introduced the arbitration regime, nor there were clear obstacles in the general legal framework on this. The main reasons that scholars found to this ban are practical ones, normally related to shareholder minority protection needs and the cost of arbitration, which, in our opinion, can be easily addressed and solved from a regulatory point of view. So, what are we suggesting with our paper? We suggest that the ban on arbitration for listed companies should be removed, and in the meantime, specific rules addressing specific needs of listed companies should be adopted. And we suggest to adopt a model for intra-corporate dispute arbitration for listed companies in Italy, which should rest on the regime already existent, that is quite balanced and good, and in introducing selected amendments just to address specific issues of listed companies. In proposing this model, we adopt three perspectives. The corporate governance perspective, and here the important thing is to ensure that minority shareholders are protected when the clause is inserted in the bylaws, and that access to arbitration is ensured to all shareholders. And here we put a special focus on costs of arbitration. The capital market perspective, here we try to find, to strike a balance between the transparency requested by capital markets and the traditional confidentiality of arbitration. The third perspective is that of arbitration law. Here we see three main issues at stake: the appointment of arbitrators in order to ensure their independence, a better definition of subject matter arbitrability, and the empowerment of arbitrators with conservatory and interim powers.
Well, of course, hold on. Okay, of course, when speaking of ICD arbitration, we must confront with some comparative pinch in order to understand the various different approaches around the world to these aspects. And I wouldn't say surprisingly, but realistically, we saw quite a debatable issue all around the world. Even though somehow there's a general consensus on the arbitrability of ICDs. However, some jurisdiction appears to disfavor agreements to arbitrate ICDs in public companies. We can identify, like for purely descriptive purposes, we can identify, let's say, three main approaches. On the one end of the spectrum, there are those countries, among which the most famous one is Brazil, which mandate the corporate disputes be settled by arbitration. Even though Brazil, generally speaking, allows arbitration clause in bylaws of listed companies, but the listing rules of the São Paulo Stock Exchange do mandate the presence of such a clause. Close to this position, we see that those countries that basically allow but not mandate arbitration clause in listed corporations bylaws, such as Spain, or Sweden. Sweden also with a specific regulation on costs, on cost bearing that we might get back to in later if we have time. On the other end of the spectrum, we have those countries which, on the contrary, expressly forbid for publicly held or listed company from adopting an arbitration clause in their bylaws. In addition to Italy, of course, as we just said, there are a bunch of other countries, such as Russia, by express legislation, or, if we're not mistaken, but the presence of so many important speakers to this conference coming from said countries might help us in let's say in assessing how true that this statement is, and therefore we'll get back to the guys from Spain or from the Netherlands and other countries in order to we'll liaise with them in order to understand, to better focus our research. But anyway, pursuant to relevant court decision instead of express legislator provision, also the Netherlands has ban on ICT's arbitration for listed companies. And probably the most famous or most renowned case is that of US, which is where this topic has recently or has been traditionally, but most recently has been a very debatable debatable issue, and their position is quite peculiar because, again, there are an interplay between federal laws, state laws, and jurisprudence that makes this case very peculiar. But anyway, in between from these two radical positions, there's the vast majority of states where basically the stipulation of an arbitration clause is not explicitly banned, or in other words, is admissible. And among these states, of course, positions are different. And for example, there are those countries where essentially historically such disputes have traditionally being adjudicated in state courts, or where case laws such as France with UK, or such as Germany, where the jurisprudence, that the case law has not yet ultimately resolved upon ICD's arbitrability for larger companies. However, this does not prevent, in practice, companies, quite big companies, eventually listed on let's say different stock exchange, such as the Royal Dutch Shell, whose shares are listed in the Netherlands, in London, in the UK, and in the US, from having a quite let's say well-structured arbitration clause in its bylaws, in their bylaws. Well, reasons for being skeptical, for forbidding such clause may be country-specific. In Brazil, for instance, the reliance on arbitration stems from those law pays of Brazilian judges, or in conducting the proceedings, or good knowledge of corporate law issues. Whereas in the US, for example, at least our intuition is that, of course, protection of minority shareholders might be in danger because the bylaws of a corporation might be amended by the directors themselves, who might then want to shield themselves from any sort of liability, preventing the more general and more traditional derivative and multi-party litigation, which is in the US at least, a well-functioning means of enforcing corporate governance and maintain market confidence. However, at a very general level, we might say that general reluctance seems to be grounded on public policy concerns, essentially relating to those points that Valentina was mentioned, and which in our view can be addressed by ad hoc rules. Then we might discuss whether at the legislative level or on a soft law basis, but still specific rules might address the main concern that most countries have, relating to, again, shareholders' consent to arbitrate, cost bearing, adequate transparency of the proceedings, and how to manage class actions and multi-party lawsuits.
So now we try to sketch what are, in our opinion, the main characteristics that the Italian model of ICD arbitration should have. And in doing this, we rely on what we already have in our legislation, and we suggest specific amendments just to make it work also for listed companies. First of all, we should address the issue of consensus principle and the protection of minority shareholder when including the arbitration law in the bylaws. Italian law already provides that the clause can be provided in the bylaws, provide for qualified quorum for the adoption of general meeting resolution, and acknowledge an exit right to those shareholders who did not consent to this resolution. Also, it explicitly affirmed that the arbitral clause is binding for all shareholders, existing and new shareholders. What do we need here? We need more transparency. Transparency on the proposal on the introduction of the arbitral clause when it is submitted to the general meeting, and in particular it is important to indicate also what is the process under which the board of directors are dragged to adopt this proposal. Once adopted, the clause in the bylaws must be disclosed in the relevant document of the company, notably the corporate governance statement. The second issue is that of access to arbitration. Here, again, the Italian legislation ensures a certain degree of transparency on the filing of the request of arbitration, which must be filed in the business register. So any shareholder has the right to know that an arbitration is ongoing. And the law explicitly acknowledges any shareholder the right to intervene in the proceedings once it's started. What should we add? We should add some rules on costs. And here we see two possible solutions. First, we can think about putting the cost of arbitration, charging the cost of arbitration to companies totally or partially and under certain circumstances. Here, the right balance to strike is not to encourage frivolous claims from minimum shareholders. The other one is to allow retail shareholders not to be bound by the arbitral clause. In this respect, they could be free to choose whether to go to court to file their suit or to go to arbitration. In the capital market perspective, as we already mentioned before, the balance to reach is between the transparency requested by capital market and the confidentiality of arbitration. We have seen that Italian law already requests the filing of the request of arbitration in the business register. Here we suggest that more transparency should be ensured, and the disclosure should be ensured also for the final award and for any other relevant step in the procedure. Finally, some indication on the arbitration law perspective. First of all, the appointment of arbitrators and their independence. Here again, Italian law allows and ensures this independence because the appointment must be made by a party outside the company, so no conflict of interest inside the companies in the appointment of the arbitral tribunal. We suggest that in the case of arbitration in listed companies, the arbitral tribunal must be always composed by 3 members. We also suggest that in case of listed companies, we must resort to an institutional arbitration. Here, if we have an institution administering the arbitration, we can be quite sure on the level of independence of arbitrators, on the predictability of costs, and on the general appropriateness of the whole proceedings. Again, the other two issues are subject matter arbitrability and interim powers of arbitrators. Subject matter arbitrability is defined in Italian law relating to the notion of disposable right. The notion of disposable right is quite uncertain in Italian case law. That's why we suggest to allow the arbitrability of any dispute relating to corporate relationship, dropping the reference to disposable right. Any dispute relating to corporate relationship has a patrimonial nature, and in that way should always be considered disposable and so arbitrable. The other issue is that of interim powers of arbitrators that right now are only acknowledged in a limited way to arbitrators. They can only suspend the effectiveness of a general meeting resolution. Instead, we suggest that broad powers should be conferred to arbitrators to be able to adopt interim and conservatory measures in any case. These are the main characteristics in our proposed model that should work for the Italian listed companies, and we propose to export eventually also at the European level.
Yeah, exactly. So this is, again, the part that follows is now really open to contributions from panelists and audience to this conference, because we somehow argue that ICD arbitration, again, has two fundamental characteristics in our view, or should have two fundamental characteristics. Should not be mandatory in the sense that a company can opt in to this mechanism, meaning that if it does so, it might do so consciously because it believes that it is beneficial for the company itself, and again, it might be complementary to the idea, which is the core of this conference, of a specialized course. However, and why so? Because there are plenty of literature that suggests that creating an EU-level specialized company law court could be beneficial for EU, because it could offer great speed and expertise, lower error rates in the face of complexity, and be an alternative, or let's say again a complement to harmonized substantive corporate law. However, the reason why, or most of the reason why this hasn't happened so far, is that is twofold at least. First, the fact that Europe is different from the US, and there cannot be or there cannot have been yet a Delaware-like court. Is that because in the US the law of incorporations is always applied, and here instead of the home country rule, which is applicable in the EU. And on the other hand, a practical difficulty is that developing effective judicial systems may take a while. So even though we purport this idea, we're not sure that this might be a resort in the short term. As such, generally allowing ICD arbitration for listed companies in EU might be beneficial, or should be beneficial. Also because opting into ICD arbitration clause or into ICD arbitration could also have signaling effects, because might allow well-intentioned corporations and entrepreneurs to send credible signals that they are committed to limit private benefits or extracting private benefits. And this might end, even though we're not suggesting necessarily a European legislative initiative, we are also of the idea that these might be addressed, or in any case, be let's say subject matter of a debate, also through the means of soft law, and develop at the level of academic initiative and also self-regulation. But this is our latest thought about that. We think that ICD arbitration might also serve what is as being emerging in the very recent past as one of the main objectives of EU company law. If we think of the Shareholder Rights Directive, the second, of course, we see that it is emphasized there the importance of shareholders' engagement in conjunction with long-term commitments, which combined should lead to better corporate governance. Well, that said, then shareholders who might be more lenient or might face less hurdle in suing a corporation by taking active role in ensuring board's performance and accountability, might serve that goal, might serve that objective, and provide alternative route for preserving governance values. Again, litigation has not traditionally been a way for institutional investors to show their engagement, but probably, this is our intuition, probably if we allow them to have resort to this mechanism, this might also be a way to show engagement and serve the purpose of better corporate governance. Thank you for your attention, and Arek, the floor is yours again.
Thank you so much, Valentina and Federico, for this thought-provoking presentation. And I hope we will have a chance to discuss this in the final discussion round. But as the structure of the panel is such so that we first have the three presentations, and then we will come together to discussion. So please let me now move to the next speaker. Maciej will be the next speaker, and I think his talk will be a nice bridge between the topic that you covered, namely arbitration and lessons from arbitration to professionalization of resolving corporate disputes. Maciej's focus will be on expert witness. This is a problem that has been raised many times during today's conference, and he will look at this taking into consideration the experience of arbitration on the one side and also of the common courts. On the other side, what are the similarities and what are the differences when it comes to the involvement of expert witness? And this is therefore a very nice bridge, because our last speaker in the panel, Krzysztof, will be focusing on precisely on the topic of expert witness and his role in the common courts. So Maciej, you are very nicely suited here to connect those two topics. And having said this, please, the floor is yours.
Thank you very much, Arek. First of all, I hope I am audible and visible. I see on the screen that my PowerPoint is on, so perfect. Great. So thank you again, Arek, for inviting me and for the ability to participate in this panel among such distinguished practitioners and academics. And I too, as Professor Rafael, feared that I come from, let's say, the enemy camp. So arbitration as opposed to capital market and commercial court system. But in fact, my role today is not to advocate in favor of arbitration over capital court system. But by the way, I'm a great advocate of arbitration in general. My task today is to compare two traditions, a Polish tradition, Polish approach to expert witnesses, and the role of expert witnesses in international arbitration, to see what are the best features for the commercial and capital market court system. So we all know that in common law tradition, expert witnesses usually give oral testimony. This is the basis, this is the principle, and they are also in principle party appointed. So party is offering witness evidence as an element of presenting witnesses. In civil law, the tradition is different because we usually have written opinions and we usually have tribunal court appointed experts, and those two words collide. I would like to discuss briefly today, first of all, what is the notion of expert reports under Polish and arbitral law. We're going to touch upon the typology of expert opinions. But what is important for me is to show how crucial and significant expert opinion may be under Polish and arbitral law. We're going to discuss other than arbitration and state court litigation means of dispute resolution, which might be also helpful in giving a food for thought or developing a good system of dispute resolution of corporate disputes. I prepared also some empiric studies on the use of expert opinions. And finally, we're going to discuss the facts in decision-making and procedure related to experts as grounds for challenging state court judgments and awards. And this would allow us, first of all, to compare advantages and disadvantages of two systems, and finally make some final conclusions and recommendations for commercial and capital market system. So, starting from the notion of the expert opinion, and under Polish law, there are little definitions. Law requires expert evidence when the court has specialized knowledge, but we actually don't know what this specialized knowledge is. There are some definitions proposed that we are talking about above average specialist knowledge in a given field of science that exceeds knowledge of the general public. But there are equally no lists of fields that require specialized knowledge. And why is that important? Because as we will see in a minute, if the case indeed requires specialized knowledge and the court fails to adduce expert evidence, this might lead to setting aside, to changing its decision. Well, there are equally no detailed legal definition of expert opinion. There are also no list of formal and substantive requirements of an expert opinion. This, in turn, leads to the result that many different opinions in different courts in Poland differ. Of course, certain kinds of opinion, for instance, evaluation of real estate, has some legal requirements stemming from different sources, but other opinions might lack the common ground in establishing what such an opinion should contain. Also, there is no legal definition of an expert, but of course, such a person needs to deliver special knowledge. But what we know is that experts under Polish law are not witnesses, and in principle, they should not testify as to facts, save for some exceptions, for instance, in expedited proceedings. But equally, they are not court employees. They are not on the payroll of the court, but still they are commissioned by the court and they get remuneration from the state, from the court. And this is again an opposition to the common law tradition where the experts are remunerated by parties. The experts under Polish law can be recruited either from a list of experts or appointed ad hoc, but Polish law does not differentiate the status of such experts. Both are good as long as they deliver specialized knowledge. But interestingly, and as compared to international arbitration, only a physical person or a group of persons can become an expert, so not a company. However, Polish law contains a specific, a different notion of a scientific institute which can deliver opinion in complicated cases. But this is on the margin of cases, because we are talking about, according to the statistics I found, 3% of opinions. So, like we said, expert opinions pertain not presenting facts, but to evaluating facts. Equally, experts do not give their witness evidence on law. However, there is an exception for foreign law. Polish court can adduce evidence, expert evidence pertaining to foreign law if foreign law applies to the case, and this is quite often an issue. And any lawyer with background in different legal system can serve an expert here. The experts, like we said, help court to evaluate facts and help in decision making. However, they will not help if there is not enough evidence to support the claim. But they may help the court realize that the claim is unsupported. And I can give two examples from my practice. First of all, the court, after receiving an expert report, realized that there is no causal connection between allegedly tortious actions of a party and alleged damage. And the court expressly said that report, which was supposed to compute the damage, actually made the court realize that the case should be dismissed. And second example, the experts can make the courts realize that the claimant or the respondent, depending on the burden of proof, did not support enough evidence, for instance, to calculate the loss. And this can also lead to dismissal of the claim. Another interesting issue is that the experts, when they lack some evidence, they quite often take the steering wheel and ask the parties to present some documents and engage in some sort of document production, which under Polish law is unregulated, unfortunately. So the status of documents that are presented with an opinion, but do not have been previously presented as evidence, is actually questionable. We still have no firm case law of that. A lot of authors argue that such evidence, such documents cannot be basis for decision making of the court. However, the parties may obviously file them separately. But even if the expert would not help the court in reaching the decision, a Polish legal system contains some sort of a safety valve that allows the expert, the court, to award damages, for instance, in appropriate amount that is totally up to the court to decide, when it would be very difficult or obviously pointless to compute the damage. Then you would probably wonder, because we were talking about tribunal or court-appointed experts, what is the role of party-appointed experts under Polish law? Well, it is minimal, because under jurisprudence of Polish courts, the expert report, the notion of expert report, pertains only to report of a person that was employed by the court on the basis of evidentiary order. So we're talking about the label of an expert only with respect to tribunal or court-appointed experts. So a private opinion, private report, can only serve as a document or a reinforcement of parties' position, and therefore, as compared to expert evidence given by a court-appointed expert, the evidentiary force of such evidence is minimal and limited. And the case dramatically changes under arbitral law. Obviously, the law, and I'm talking here primarily about ancestral model law on international commercial arbitration prepared by Ancestral in the 80s, and all the legal systems that base their arbitral laws on that law. Those laws usually also do not contain definition of an expert report or an expert, but model law expressly allows tribunal-appointed experts in Article 26. Despite the fact that the model law does not touch upon the issue of private opinions, private appointed experts, most or all authors accept party appointed expert evidence, under a general rule allowing party to present the evidence. And also, what is important, arbitral law, as in many aspects, require the parties to be treated equally and give them ability to present their case. And that is why any evidence, in particular expert evidence, should be also presented to the parties. The issue of expert is further discussed in arbitral rules. Well, because the model law does not talk much about or none about party-appointed experts, those rules usually allow them explicitly, and also underline, which is a basic principle of arbitral law, the influence of the parties. So the parties have the deciding voice on how to shape the evidentiary proceedings, including the expert evidence, and this will be important for our further discussion. Moving forward in the sphere of arbitral law, after discussing the hard law, meaning law and arbitral rules, we also have quite a lot of soft law instruments, and I would like to talk more about two of them. We have, known to most practitioners, IBE rules on taking of evidence in international arbitration. And the rules, which are very popular, widely recognized, and forming basis of many arbitrations, they mention explicitly and give detailed rules on both party and tribunal-appointed experts. Well, in the rules themselves, there is no preference given, but a lot of authors accuse, let's say, IB rules on preferring party-appointed experts, and that was the reason for adoption of Prague rules, but we're gonna reach them in a second. And as IB rules discuss party-appointed expert in detail, they set forward requirements for expert reports, which is important. For instance, the experts must outline the methodology, evidence, and information used in arriving at the conclusion, which is important, which is not always the case in Polish-based tribunal-appointed expert reports. And also, they solve the issue of the documents. For instance, it happens quite often in Polish litigation that the expert opinion is based on some documents that the expert obtained from the parties but not disclosed them. Here, under IBE rules, there is an obligation of an expert to disclose all documents that form the basis of the report. However, which is also quite interesting and gives some sort of a chance to attack IBE rules. The IBE rules do not require the report to be correct or to be truthful. In Article 5, Section 2, subsection G, the rules require the expert to present, I quote, an affirmation of his or her genuine belief in the opinions expressed in the expert reports, as opposed to the truth. And this touches upon the issue of so-called hired guns, so private experts being advocates of parties and not impartial and independent court assistants. We're gonna get there in a minute as well. And this critique was a basis for preparing another document a couple of years ago called the Prague Rules. Prague Rules, as opposed to IBA rules, which have a general international character, Prague Rules are based on a civil law tradition. So the tribunal-appointed experts are preferred in arbitration under Prague Rules. However, party-appointed experts are still possible. Also, what the Prague Rules tackle is the critique towards party-appointed experts, namely the so-called ships passing at night. So, two opinions of expert witnesses that are completely different and have nothing in common, and therefore make tribunals' case very, very, very difficult because the two reports are uncomparable. So the Prague Rules allow the tribunal to impose, first of all, witness conferencing, expert witness conferencing, or joint report of party-appointed witness, and that should help with that issue. Of course, there are other soft law instruments. For instance, the Chartered Institute of Arbitrators prepared a protocol on the use of party-appointed witnesses, which is a good example on how to tackle formal requirements, the independence of private experts, and it's very useful. Going on with the presentation, of course, we have different types of expert opinions. We have written and oral, and written are usually used in Polish courts, but usually courts also call the expert witness to the stand. We have the main opinion and supplementing opinion if the parties are discontent with the first opinion. We have an abstract opinion, for instance, opinion on the issue of law that does not generally touch upon a given case. And we have a concrete opinion that deals precisely with the case at issue. We have party appointed, we have tribunal appointed, individual experts, we have group of experts, but all of them important under Polish and arbitral law. Why? Because, as we touched upon previously, an expert opinion under Polish law cannot be replaced by any other means of evidence, so witnesses, documents. No, only you can, as a party, use an expert opinion from other proceedings, since a couple of years ago, after the law was modified. So this means that the court can appoint an expert upon a party motion. It can do so even without such a motion. But what is the most important, it even has to appoint an expert witness, even when there is no such a motion, when the case requires special knowledge. Otherwise, as we will see, it risks its judgment being set aside. On the other hand, if the case does not revolve around special knowledge, the court cannot or does not have to appoint an expert witness. And this is completely different in arbitration, because the role of experts in arbitration is not so formalistic. The experts assist parties in presenting the case and assist experts. So I can imagine, and I saw that in arbitration, that the tribunal appointed an expert witness just to do the maths, just to compute the numbers that were stemming from the facts of the case. This is not a specialized knowledge. Everyone can use Excel, but it's obviously possible in arbitration. So the expert reports usually or often relate to issues that do not require specialized knowledge, and quite often they relate to legal issues where the arbitrators are not familiar with a given legal system or applicable law. And like we said, here the party autonomy is crucial, as stated by the Polish Supreme Court. Parties in arbitration can even decide that the expert witness evidence is not required at all. Or they can decide that the parties shall submit their own party-appointed expert reports, and the tribunal will not appoint a tribunal-appointed expert. They can agree on tribunal-appointed expert. So sky's the limit, and what is important is that their autonomy should, and their voice should prevail. And what also prevails in practice are private party-appointed expert opinions. Why? Because they usually allow the dispute to be resolved quicker. And the timing issue, despite the critique of modern arbitration, is one of the issues, one of the reasons why parties actually select arbitration over the state court system. But not only arbitration is connected with expert evidence, we have also an expert-oriented means of dispute resolution that go beyond the state court system. First of all, for those familiar with the FIDIC rules, we have dispute adjudication boards. So panels of experts, usually engineers, sometimes lawyers, but mostly engineers, that are deciding on parties' disputes not after the contract was implemented, but during the implementation of the contract, and usually within very short deadlines to keep the construction site running. And that's very important for the construction industry, but quite often those dispute adjudication boards are used in different industries, for instance, IP. And we have also expert determination, for instance, under the rules of the ICC, International Chapter of Commerce. So in cases when parties need the expert opinion in their ordinary case of business while implementing the contract, but also if they are negotiating or they are on the verge of a dispute, they may adopt expert determination. However, the expert determination of the parties so decide may be binding upon them, but this is not an arbitral award, nor it is, of course, state court judgment, so they have to go to court or arbitration to enforce their rights stemming from such a report or document. I've given a bit of a theoretical background, but let's see how does this operate in practice. So I've got two reports on the use of expert witnesses in Poland. We have a Helsinki Foundation Human Rights and Polish Business Roundtable report of 2014, quite a long time ago, but believe me that I believe that the findings are right still. So obviously remuneration for experts should be higher, experts are underpaid. Courts should have more powers to discipline experts because they usually don't present their opinions on time. There should be a general list of experts and not a list of experts in a local court that would allow the courts to reach for either the best experts or the experts that can actually do the opinion, prepare the opinion on time. And obviously, despite a direct legislative basis in Polish law, parties do not always have a say at the appointment of experts, and they should have a deciding voice here because it's their case after all. We have also a Justice Institute report of 2016, and it gives some ghastly numbers. So first of all, average time for the main opinion is 70 days, which is not that bad, 2 months. But if the parties are discontent with the opinion, and it's mostly the case, the average time for the supplementary opinion in Polish court is 200 days from filing of the main opinion. So we've got 270 days, almost a year, just for the expert report, let alone discussing other evidence and hearing witnesses. So in 50% of cases, the experts were late with the reports. What we will see in an example in a while, in 90% of cases, after the parties commented on the witness reports, the experts did not change their stance in any way. Obviously, the report repeated some other arguments, including the argument about the general list of expert witnesses. But let me give you an example I found recently on one of a Facebook page for Polish lawyers. A lawyer came back from the court and was very tired about the situation and asked what to do. So he was hearing an expert witness in a case pertaining to costs of construction work that was not done by the construction company and had to be commissioned to other company, and the costs of such commissioning were in question. So the experts should have given the court numbers. So what construction of a home, of a house, how expensive it is, and what are different positions on the list. One of the positions on the list was plastering, so putting a plaster on the wall that you can see in the picture. So the lawyer learned from the report that the expert witness, instead of computing the cost of the area of the wall, actually computed the volume of the room. So as if the construction company would fill the whole room with plaster instead of just putting plaster on the wall. Obviously, it made comment in writing about the report. The expert said that everything's perfectly fine. It even came to the hearing to question witness, but the case was taking so long that the court, either knowing there's something wrong with the opinion or not knowing, but wanting to conclude the case quickly, just made the final judgment using the numbers given by the expert that were, of course, exorbitant, because he made a silly and simple mistake that is quite easily visible to every one of us, even here, not having expert knowledge. But this example gives you, in a nutshell, the problems of Polish court system and experts. So the experts are underpaid, the quality of the work is sometimes low, but the courts are also unwilling to change something as long as they have a number that they can base their opinion upon. They wash their hands and not intervene. But as far as examples are concerned, or surveys, I also made a survey on my LinkedIn. So just to confirm, which seems to be obvious, and it is obvious to many dozens of our friends and practitioners and academics. So I asked them, in terms of the effectiveness of the report, which kind of a report is more effective for arbitrators? And you see that nearly 80% of the stakeholders said that the court or tribunal appointed expert report is better, more reliable, probably. Whereas the numbers are reversed if we ask which expert report allows a party to more effectively present the case. Obviously, party appointed expert opinion. Also, we asked about the costs and time, and as long as the party appointed expert allow the parties to save time, 60% said so. Also, 60% of respondents said that the court tribunal appointed expert can save costs for the parties. We'll see whether this is particularly true, because I'm not sure if the respondents taken into account the so-called shadow experts' opinion. And finally, we ask if there would be one model of expert evidence allowed. You see that nearly 2/3 of respondents said that they would welcome court and tribunal appointed expert witness system and resign from party-appointed systems. And this gives a bit food for thought, especially for the commercial and capital market court system. But we're going to reach that in a second. So you have a background, you have a good overview of two systems, and you've probably seen that in Polish litigation we have underpaid and overburdened experts that present their expert opinions very late. And we have a limited chances of the experts to combat parties that are refusing to cooperate, despite Polish courts being able to impose or draw adverse inferences. But on the other hand, we have a reliable, impartial, and inexpensive opinion. Of course, this does not take into account the cost of some so-called shadow opinions or shadow expert opinions. So that in most cases before Polish courts, if the stakes are high, a renowned law firm would probably hire a private expert to help lawyers to evaluate the tribunal appointed or court appointed experts' work, and this also adds costs to both of the parties. In terms of arbitration, we've already said that we have party-appointed experts that usually do not have to present an accurate opinion, but opinion based on their belief. So they're called hired guns. We also have a problem of opinions that have nothing in common and are comparing totally different things. We have the issue of costs, and especially legal aid issues. So in arbitration or in a dispute resolution system that operates under the assumption of party-appointed expert witnesses, a party may not be able to afford an expert at all. On the other hand, we have tribunal-appointed. I see, Arek, that my time is running up, and I'm wrapping up my presentation. And we also have to tribunal-appointed experts an accusation of being de facto arbitrators. But on the other hand, this all allows to resolve the dispute quickly. Let me quickly pass to final conclusions and recommendations, and leaving the defective decision-making maybe to other discussion. So we got, when adopting a court model for commercial capital market disputes, we have a first model that operates under the assumption of tribunal or court-appointed opinion as the only or the primary source of expert evidence. This is, of course, a civil law background and has some drawbacks: time, quality, but it equally has some advantages: costs and control of the court or tribunal over experts' work. And we have a second system. Let's call it Model B, where party-appointed experts become either the only or the primary source of expert evidence, and it is common law background. And here the drawbacks and advantages are reversed, are opposed to Model A. So we have costly opinions that are not being controlled by the tribunal, but they are delivered quickly and the quality is usually high. I would be very happy to hear your thoughts about this system. I just think that some of the issues that are regarded as drawbacks of the Model B can be easily overcome, and I'm leaning towards the second system, contrary to what was stated by the stakeholders in my survey. But like I said, I'm very happy to hear your thoughts, and thank you very much. Thank you very much for the floor, and hope to engage in a discussion afterwards. Thank you.
Maciej, thank you so much for sharing with us this perspective. as I mentioned in the introductory talk, you have a lot of experience, hands-on experience, and I hope in the discussion we will be able to. What you said, much of this has a general nature, and I hope we will be able to narrow it down to corporate and capital market aspects. Now, since we are lagging behind time, and we have our last speaker in today's series of talks and also for this panel, but I am thrilled to hear his presentation, because the track record of Krzysztof and his perspective is hugely interesting, I think, because he will share his knowledge as one of the highest in demand witness experts in Poland, called by the courts to deliver opinions on mostly financial instruments, and has experience both in civil litigation and also criminal litigation. So Krzysztof, I am certain I am not the only one who is very much looking forward to your presentation. We are all looking forward. So the floor is yours.
Okay, thank you very much. So I will try to be short, but I would like to begin with some comment to Professor Piotr Stanisławiszyn presentation during the previous panel. He told us that that specialized court should exclude criminal cases from its recognition. Then in the discussion he has corrected himself that maybe not at the first stage, because those criminal cases are much more difficult than civil cases. So in the second stage, maybe we should include also those criminal cases. And in that, I do agree with him, because I'm giving opinions mainly in criminal cases, but also in some civil cases. And the typical opinion in criminal case takes me 100 to 200 hours of hard work. The shortest one was 20 hours. The longest one, which took me almost a year of hard work, it was over 1,200 hours. So it's not easy, not an easy task to prepare the opinion in such a way that the judge can understand what is in that opinion. So let's start with definition of market manipulation. We have regulation of European Union, well known as MAR, Market Abuse Regulation. And there's a delegated regulation, Commission that delegated regulation, which in Annex 2 specifies 86 very detailed entries. And those entries are very detailed, but they are still so vaguely defined that it's very difficult to understand them for people who are not experienced in that business. The next problem is that in Polish law, those criminal sanctions are provided not in one act of law, but in two acts of law. Law on trading in securities, it's about market manipulation and inside information. And the second act of law on public offering, which deals with prospectus and inside information also. In both cases, the sentence may be up to about €1 million or up to 5 years in prison, or both sanctions applied together. Maciej has explained us that there's no central list of expert witnesses, and that's a real problem, because there are 46 registers at 46 regional courts in Poland, and each of them has its own list of expert witnesses. And there's no real definition of the fields of expertise. So I have studied all those lists that are accessible at the internet, and counted 18,078 expert witnesses in all different fields. But after elimination of double entries, it makes some 17, maybe 18,000, because some experts are specified in different fields, so that they are specified twice or even more times in one list, and some of them are listed in several registers. But when I tried to calculate how many expert witnesses we do have in securities trading field, and they are registered only at 12 regional courts, so 34 courts have no expert witnesses in capital market, in securities trading. And there's an extremely small total number of no more than 18 expert witnesses in that field. I have written here no more than 18, because when you read the description, you can only guess whether they are expert in that field or not. And half of them, 9 expert witnesses, are registered in Warsaw. So you already can see here the specialization of Warsaw. There's a need for experts in that field only in one city in the capital of Poland. There is a specialized prosecutor office. All market manipulation cases that are identified by Polish Supervision Authority, KNF, go to one specialized department at the regional prosecutor office in Warsaw. Then the prosecutor transfers the case to the police. There is a specialized department at the police metropolitan police headquarters of Warsaw, and then such a police department asks an expert witness whether he can prepare an opinion. And there's the one problem, because the expert witnesses are paid very small amount, but the police has even less money, so that they have to ask 3 candidates for how much their opinion will cost. The police has the obligation to choose the less expensive opinion. So just at the start, the police has to choose the expert who declares that his opinion will be the worst one, because he will use very short amount of time for preparing the opinion. Sometimes they have a special acceptation from the chief, from the prosecutors of central prosecutor office to ask for the more expensive opinion, not for the less expensive. But the problem still exists. But after the case is prepared, it goes to the court according to the place of residence of the defendant. So it does not go to the court in Warsaw, but somewhere in Poland. So in theory, a judge in such a court has to assess whether an expert witness opinion is reliable, and to pass a sentence based on his judge adjustment of the case. But in practice, a judge that does not understand the business aspects of the case. And my role, very often, I have to teach the judge what the case is about. So how the judge can assess whether my opinion was reliable on the basis of the knowledge he has just acquired for me during the sitting. And so in practice, an expert witness opinion in such cases is automatically converted into court sentence, which is very bad. And I would like to show you one example where if you can see something on a diagram, but when you study the diagram exactly, the real picture is quite totally different from that picture that is prepared by an expert using the Excel worksheet. There's one case of manipulation. It took a long time, several sessions, but here is one case from one session where investor called XX was buying shares, that blue dots, and selling shares, those red dots. When you look at it, he was buying shares at the average price. He was buying shares on that during that session was 960 zloty, and he sold those shares at the average price of 10 zloty 10 groszy. So, well, it's quite okay. This is the role. You should buy shares cheap and sell them at higher price. Then you have some earnings. But when you look here at those lines, the first hour was he was raising up the price. The second 2 hours he has stabilized the price. Then he sold the shares, and then he was buying shares at the higher price. But finally, when you look, the price of the shares was not going higher than 11 zloty. But let's study that small area of 75 minutes. Now we can see the diagram for those 75 minutes. And you can see the price was about 10 zloty for almost all the time, and twice for short periods it raised up to 12 zloty. But that period of price at 12 zloty was for just 19 minutes. Then a period when the price was lower was only 29 seconds. And then for almost an hour, the price was remained still very high. But when you put that diagram in a real-time perspective, you will get quite a different picture. So you can see that for almost all the 75 minutes, the price was very high at 12 zloty limit. And only for 29 seconds, the price went down when that investor was selling shares. So the real picture is that, and what is even more important, that he sold 1,900 shares, but he kept the price of shares at very high level, with 9 shares before and with 20 shares after. So this is a typical example of making very wrong impression when other investors look at the price of the shares. They believe that there's something who is buying shares for 12 zloty, but in fact he's not buying shares at 12 zloty, but he's selling shares at 10 zloty. So what are dangers and irregularities? The Dutch has no tool for assessing reliability of the opinion of the expert witness. The case is not set by the court, but by the expert witness, but with no practical and legal guarantee of his impartiality and his independence. What is even worse, the expert witness is burdened with a full responsibility for the court sentence. What is even worse, that responsibility means that if I make an unintentionally false opinion, so if I make a mistake, not an intentional, I can receive a criminal sanction of 3 years in prison. Well, this is very, very dangerous for expert witnesses, and I can easily understand why nobody really wants to be an expert witness in such a situation. And what is even worse, that the defendant is deprived of real pledging rights. So, in my opinion, the only solution is to have specialized court or courts, maybe in the beginning for civil cases, but finally it has to include criminal cases also, with judges qualified enough that an independent body, maybe the court, that specialized court, should be able to assess qualifications of expert witnesses. The central register of expert witnesses, and but with real tools for monitoring of their experience and qualifications, because now anybody can become an expert witness in capital market cases. No diplomas, no papers are required. If I go to the court and say, well, I want to be an expert witness in capital market cases, and the court is so happy that he writes me into the register. And impartiality of those witnesses is not monitored now. Independence sometimes, when the parties claim that the expert witness is not independent. And what is finally, only in such an organization, education and training system could be performed, but not only for courts, not only for prosecutors, not only for police, but also for expert witness, because all the knowledge I have earned is my experience, my personal experience. I have had no lectures, no trainings. I had to come to that expertise by myself. Well, thank you very much. Well, that's all.
Krzysztof, thank you so much. You are known not only for your competence and expertise in the capital market and financial market, you are also known for always adhering to the schedule. So I appreciate also that you were able to cover this in a time provided. So with this, we are now ready to open discussion. We will have a chance to exchange ideas in the forum, but also if there would be any question for every panel so far, there have been some questions from the audience. I will be looking there if there are any on the Facebook, but I also saw that more people were following us on YouTube than on Facebook, but if there are some questions, I will also read them loud. Please let me start with a joke, because much of this panel has to do with trying to draw a line between what the court should understand and where this knowledge ends and where special expertise is needed that is brought by the expert witness. And this joke is as follows. We have three actors on the stage, an eyewitness, an expert witness, and the judge. And the eyewitness is a person that saw everything, but understands nothing and decides about nothing. Then we have an expert witness who didn't see anything, but understands everything, but still decides about nothing. And then we also have a judge who didn't see anything, doesn't understand anything, but decides about everything. And I think with your presentation, you contradicted this truth stemming from this joke, because as you know, jokes usually convey some truths in a very funny way. So the truth here has been, I think, quite convincingly contradicted, Krzysztof, by your presentation. That actually boils down to a very bold statement. The one who renders the judgment is the expert witness. I have a couple of questions to all the speakers. Enrico, I don't know if Valentina is still with us.
Yes, I'm here.
Okay, you are both. Okay. My first question would be, the topic of this conference are specialized courts, and we see arbitration as just an alternative and a part of the broader context. The question would be, assuming in the audience we had an Italian Minister of Justice, and he would like to have some takeaways, not for reforming arbitration law, but to install a specialized court modeled maybe after the Dutch Enterprise Chamber or maybe after the Israeli one. Would installation of such a court make the room for arbitration in Italy redundant, or would it not? This would be my first question. So, or putting it differently, is your call for extending arbitration to listed companies only valid as long as there is no state court, or you would consider this independent ideas?
Actually, I would consider it independent. And in Italy, we have specialized courts for business disputes. We see arbitration and traditional court as complementary, and we would like to enhance the possibilities offered to investors and companies to solve their disputes. Also, we believe that it depends very much on the structure of each company to decide to have an arbitral clause in the bylaws. And we see especially use of arbitration in smaller issuers, probably listed on alternative markets, such as a small SME growth market, where less shareholders are in, more professional investors are in, so they might be more interested in this kind of dispute resolution mechanism. So I think that the two systems should coexist.
If I may, I basically share this view. Even though I see where you're coming from, Arek, and I might say that generally speaking, that might have that effect. That is, having specialized courts deciding in a timely manner would definitely help enhance the system and possibly reduce the tendency, the tendency of investors to go to arbitration. But I agree with Valentina. They should be complementary. They are not mutually exclusive. But again, for example, I would say that Italy might look closer to Brazil in that respect, in the sense that in the absence of proper institutions, it is better to have arbitration.
I see. Another question is maybe for the sake of proper understanding, because the general term that you were using were corporate disputes. Now, to make sure, because this very notion still might be quite broad, even if we are talking about specialization, if we are trying to focus on a narrow field, this narrow field is not as narrow if we look closer at this. We might have some disputes where the number of parties is rather limited. It obviously might affect a larger number of parties, but the very number of parties directly involved is limited. If you have a dispute that stems from an M&A transaction, if you have a dispute between a buyer and the seller about the title transfer, about whatever claims based on warranties and representations, there the number of parties affected is rather clear. But in continental European countries, where you have rather, in many companies, if you have rather concentrated ownership, much of the shareholder litigation is about challenging these resolutions by the general meeting. This is an experience quite different from the one made in Anglo-Saxon countries, where most of the disputes are between the managers and the shareholders as a group. So there, in a listed company, you have hundreds of thousands, if not millions, of shareholders. I would like to make sure that in your proposal, you would like to embrace this category of claims as well.
Yes, we would, of course, include this. The issue here is, on one side, at least according to Italian legislation, any shareholder can intervene in an arbitration who is started by another shareholder. But clearly, one should reflect on the idea of class action and if it can be imported in the arbitration system.
And
Yes,
thank you.
Yeah, go ahead.
Yeah, you wanted to add something, Federico?
No, just once again, the thing is, it might result in a practical issue. We do not see any ontological hurdle in admitting that. Of course, arbitration is not the exact substitute for specialized courts, and we're not claiming that investors should only go to arbitration, or arbitration is the only resort for assessing and adjudicating corporate and, I would say, securities law disputes. And for that reason, we say that it is just a matter of carving, of tailoring ad hoc rules in order to adjust that mechanism to the bigger audience, as in a multi-party action.
And my final question to the presentation by our Italian colleagues would concern protection of minorities. You mentioned in your presentation that the cost could be a problem, and we want to avoid a situation when the cost is prohibitive. Do you have any ideas how would you internalize this cost? We have some experiences from derivative actions in different countries have different cost rules, and the idea is basically the same. If there are some minority shareholders pursuing a goal that should be seen in a way as a goal of general interest as well, there are different rules that shift the costs between the plaintiff and the company. So is it something that you would consider as a model also for the cost rule on when it comes to arbitrating corporate disputes? And another subcategory of the wider problem of minority protection would be, now think of a day we have this, right? So this is the day zero when the companies, listed companies in Italy, can opt for arbitration clause. Now, with the very day they decide to do so, there is something that is changing for the company. And correct me if I'm wrong, but it seems to me that for non-listed companies in Italy, whenever you implement an arbitration clause, it triggers an exit right. It triggers an appraisal remedy for dissenting shareholders. So would you consider the same for listed companies as a means for protecting shareholders when you change the regime of rights enforcement?
First of all, on costs, yes, we suggest that costs could be at least partially charged on company, but under specific conditions. And we would like to avoid the risk of frivolous claims. And in this respect, we may think about linking the costs charged on companies to the fact that the request for arbitration is not manifestly groundless, and also if it is filed by shareholders representing a qualified percentage of share capital, especially if we say that retail shareholders may always go to ordinary court. As to the exit right, yes, in this model, we keep the exit right also for listed companies. Actually, this should be a major obstacle in introducing such a clause, and we can think over and more deeply on this specific aspect. I want to add just one thing. We say that companies may be charged of cost for the exercise of right from shareholders, but it also happens in other parts of company law. If you think about shareholder identification, in Italy we have a rule which allows minority shareholders to ask for shareholder identification, and in this case, companies can be charged of the cost itself. So it is not a principle which is not known in our system. So we can refine it, but it can be used somehow.
And also, if you let's say if we develop, if we build a sort of institution, arbitral institution that I would say oversee or let's say organize or help organizing the corporate disputes arbitration, that might intervene also on costs. I mean, the fees of the arbitrators might not be enormous. There might be some standard market standards on how much an arbitrator should be paid. For example, depending on the value of the controversy, for example. I mean, so this is clearly an issue, the issue of costs. But either costs might not result in such a huge amount, or we can find some sort of mitigants. But again, it's a matter of decision. It's a matter of rules that can be established.
And if I may add one last thing, also litigation in court is costly. You don't have the cost of arbitrators, but you have the legal fees, so it is costly. And from the company perspective, probably to be able to have a decision in shorter time might well justify the charge of partially of the cost of arbitrators.
Yeah, it's a sort of trade-off.
Yeah.
But thank you for the questions.
Yeah, thank you for addressing those questions. This is very, very insightful. Thank you. If we might move forward now, we had two presentations that presented like different angles looking at the problem of expert witness. And Krzysztof, you presented some numbers telling us that the percentage of expert witnesses that have competence in trading with securities is rather small. But in order to have a better idea, we should also take into account the number of cases, because clearly the number of cases based on securities trading cannot be compared with, say, traffic accidents. And it comes at no surprise that you have way more experts on traffic than you have on securities trading. So what is it, if this small number remains in relation in a way with the number of cases? And well, this would basically be a question that would in a way supplement these figures that you were just presenting.
Yes, the number of cases is really small. There's very difficult to get strict numbers, but as the procedure for selecting an expert witness is so as I described, I believe that I see almost all the cases that are directed to the prosecutor by the KNF. So it's about 15 to 20 cases a year. There are also some cases where courts asks me for an opinion, but I believe that it's no more than 20, 30 cases per year. That's another reason why they should be concentrated in one place, because with such a small number of cases, there's no sense to educate all the judges in Poland in that field. Because the probabilities, simple probability says that those educated judges will not receive the case. But there's another problem is with the small number, those 18 expert witnesses is not enough, because as I can assess by my experience, only 2, 3, maybe 4 expert witnesses from that number of 18 are really good experts. So I have several cases when the opinion waits for me. Now, when there's the question whether I can prepare an expert witness opinion, my answer is yes, but no earlier than in 2023. Well, that's the answer. We are lacking not only experienced judges, but we are lacking the number of expert witnesses.
Thank you. I have a question that is addressed to both of you, Maciej and Krzysztof. And well, the problem comes up all over again, the dividing line between what is expert knowledge and what is basically knowing the law. Are there any cases from your practice or whatever other experiences or knowledge you might have where it was in a way challenged, because if the court asks an expert witness and the expert witness comes up with something that should actually pertain to the understanding of the law rather than some technical or whatever as knowledge, it could be then, for instance, challenged on appeal that the what has been delivered is not about this very knowledge, because there are at least two fields where this dividing line is blurred: intellectual property and financial regulations. Because whenever we have medical malpractice, whenever we have traffic accidents, whenever we have problems with construction, then it is rather clear to differentiate between what is this technical special knowledge and what is applying the law. But whenever it comes to the patents, for instance, intellectual property, or whenever it comes to financial instruments, it is quite difficult. So is there anything that you could say from your practice where this has been in a way mixed up?
Well, it's very often because I am often when I am called to the court, the most typical question is, well, you say this was a manipulation, but what is a legal ground for that? Then I have to take out that MAR regulation and that delegated regulation, and read those 86 entries and explain why one specific entry applies to that case. So I have to explain the law and apply the law to the specific case. And it should not be my role, but there is no other way. Because the judge, I can remember half a year ago when I was called to the court, and after my examination by all the parties, the judge thanked. The judge told, "Well, I have to thank you. I have to thank the expert witness for such a great lecture, because only after that I do understand what the case is about, because when the parties explained the reasons, I could not understand anything."
Maciej, would you like to add something to this?
Well, I don't have any particular case, but I have a general comment that indeed quite often the line between the law and the expert evidence is blurred. But what is even more important is that even if we raise those arguments, it's very difficult to convince the court that the expert opinion is flawed, for instance, because it discusses law instead of facts. Why? Well, it is some sort of a paradox, because Polish case law, under Polish case law, the fact that the party is simply discontent with the expert witness's opinion is not sufficient for an appeal. On the other hand, you cannot question the expert witness report without expert specialized knowledge. So it's a paradox. And that's why it is very difficult to succeed on the appeal based merely on the attack against the expert witness's opinion. So that would be my first comment. The second comment is that those issues are maybe redundant in arbitration when the party's autonomy is prevalent. So the parties may agree on the scope of the opinion, and they also can agree that an opinion might cross this line, so that some legal arguments will be given by experts. As long as the parties are happy about it, why not? The only risk here is that there is a case from Supreme Court and earlier Court of Appeals in Wrocław in Poland, where this party autonomy was violated.
So the parties agreed first on the party-appointed experts, and those expert opinions were unconvincing to the arbitrator. It was a sole arbitrator. And the arbitrator said that I'm unconvinced, and I'm going to probably appoint an expert witness, so a tribunal-appointed expert witness. And both parties agreed to that, and even motioned for that. But later on, the arbitrator changed his mind and ruled in favor of one party. And this award was set aside, not because you cannot base your opinion on party-appointed expert evidence, but because the arbitrator violated party autonomy, because parties agreed that there needed to be an extra opinion by tribunal-appointed expert.
Thank you. We have one, it is more a comment than a question from our colleague, Dr. Ariel Mucha, who will be the speaker, who will be one of the speakers next Friday. He says that the market abuse regulation is very specific because it's a translation of market practice into legal provision. So no wonder that experts like Krzysztof must first explain what the law really means. So more comment than a question. Krzysztof, do you take notes? What is your success rate, more or less? How often does the court follow your opinion, and how often it does not?
So in this aspect, my record is very high, because I do not know any case where a court did not follow my opinion. Sometimes the defendant tries to argue that I'm not independent. In some cases, the judge decides well, so my opinion is dismissed, but not because it's their own opinion, but because there are some doubts. I doubt that those doubts, but this is the current decision. But I sometimes I have to deal with some wrong opinions. But I can remember only one case when the court has collected several opinions of expert witnesses. There were 3 opinions, different in the results. So I was asked for assessing the opinions of those experts. No, not really assessing, because it's not my role of that, but to determine what was the real situation. And all 3 opinions were mistaken in several very important details. All those 3 opinions were different. So they were dismissed by my opinion level.
Thank you. So from what you are saying, I could summarize. Above Polish judicial system, there are just 2 powers who are even higher. One of them is the Court of Justice of the European Union, and the other one is Krzysztof Grabowski, but only one of them is currently undisputed. We do not have more questions on the Facebook, but maybe you have questions that you would like to address to one another.
Well, I would have a lot of questions to Maciej, because he had no time to finish his presentation. But I believe that I will be able to see that the whole of your presentation, and then maybe privately ask you all those questions.
With pleasure, obviously.
Under normal circumstances, please, Maciej.
Yes. I just wanted to confirm that it would be my pleasure to discuss it afterwards. And the same, of course, with Professor Rafael and Madame Malotti as well. I also noted some questions, but I would be happy to see the presentation in full and discuss them perhaps by email.
Normally, I would say this discussion could be continued in a less formal setting during a networking dinner, enjoying also a glass of wine, and there are really some good Austrian wines down here. I know I see the smile on the face of Federico because Italian wines are excellent, but believe me, there are some good Austrian wines here as well, very just nearby in Burgenland, and I sacrificed myself to do the selection, a demanding job, but I did it for the sake of post-conference dinners. But then the pandemic came, and well, we will need to look for another chance to convince ourselves. Since we are already slightly beyond the schedule, there is no place now for concluding remarks, and the main reason why is it not the time now, we are just halfway through, because we will continue next Friday, and after the conference that we hopefully will be able to hold on site, we will try to have first concluding remarks, but the real conclusion of the project will be hopefully a very needed book on that topic. There are not so many, and I think we get to understand better why, because the question is multifaceted, complex, and there is no obvious group of people that could work on this, because as we have people bringing expertise from different angles, different fields, but the topic in some countries is quite hot right now, and some other countries already have this experience that can share with us, and there is no better way just than the one learning from one another. So thank you to you, my panelists, and to everyone who spoke before, to all the chairpersons of the panels that we had before, for your questions, presentations, and for being with us in spite of this circumstances that are not as rewarding as if we could have a chance to meet afterwards. So thank you so much for your contribution now towards this conference, and I very much look forward to your contribution to our emerging book. And having said this, I would like to finish the first day of the conference and welcome, and I would like to invite everyone to join us on next Friday here in Vienna at the premises of Polish Academy of Sciences. Thank you and goodbye.
Thank you.